having business to do before this court will draw near, give their attendance, and they will be heard.
Thank you. Please be seated. First case on for argument today is People versus Dibrango, excuse me. Case 428.
Morning.
Proceed, counsel.
Good morning. May it please the court. Adam Amiro for defendant appellant Marcus Dibrango. We raised 3 points in a brief, and I'd like to focus today on the first point, specifically just trying to ensure that we properly and clearly distinguish which issues that we're raising as grounds and which that were merely for context. Specifically with respect to his motion to withdraw his plea based on the grounds of actual innocence. That he pointed towards the contradictory statements that the alleged victim made to the PSI as opposed to what was attributed in the police report. He also at the trial court raised the issue of coercion. That's not brought up on appeal as an independent ground, just merely to give the context for why he would plead guilty when he actually was professing his innocence. And it was based on the fact that he was told, or as he reiterated at sentencing, that he was told that he faced up to 25 years, that at the time he thought that the alleged victim... He was
told he would face the conversation between him and his lawyer.
Him and his lawyer, yes.
Those are outside the record.
Outside the record. I'm just reiterating what he did say on the record. Right. Like I said, those aren't independent grounds, but just to put his mindset at the time when he had, it's on the record that he confessed to all the elements of the crime, but then later said that he just said that because of what he was told.
He claimed he was told that he could be charged with attempted murder.
Yes, that's what he claimed. Now, again, that's all outside the record.
Indicted.
Yeah.
He wasn't indicted for attempted murder.
Agreed. There was some issues about a phone call that he made from jail, though the contents of that call were never placed on the record. So we're not really sure, but it does appear that it was open to some interpretation.
And the record does seem to indicate that he and his attorney were made aware of the content of that phone call, though.
Yes, and he actually said that, I made the call. I know something to the effect of, I made the call. I know what was said. And then when it was brought up during the plea allocution, he said, no, that's not what I said. I was referring to something else entirely, and it was never really clarified what it was. It's kind of accepted, okay, I read it as an acceptance that there was a disagreement as to the possible interpretations of what was said in that call. And again, so I believe that the possibility might have been out of that, but again, that was not on the record other than how he brought up his recollection of the off the record advisement. And again, we're not arguing on appeal that advice that he could be charged with attempted murder should be grounds to vacate the plea, only that just helped to give some mindset to why he would. And with that also, although he did admit to all the elements of the crime, he also explained that he was told that he had to admit to all those separate things. And then when you look back at the record, although those weren't on the record, his explanation on the record of what happened coincides, where there was a recess. He was brought back, discussed with his attorney, then brought up, and immediately thereafter, the plea court advised him of what the elements were. So if he had been told that, the court had almost immediately repeated that to him.
Having practiced many years ago in criminal court, it's a regular occurrence during pleas.
Yeah.
Where when the colloquy is happening, that the defendant gets maybe a little flustered, a little confused, and there are adjournments for, hold on, apparently the client doesn't know what he's saying or understand what he's saying. Counsel, go talk to your client, and then they come back. If every time that happened, it would be grounds for setting aside the plea based upon a misunderstanding. And based upon something that's not part of the record and a conversation between counsel and his client, I fear that the criminal justice system and police would grind to a halt.
No, and I agree. Again, it's just, again, given to kind of, it's the context where his explanation of what happened and when it happened is plausible based on what is on the record. Again, the fact that they did have a conversation off the record isn't what we're trying to raise here. It's simply that it coincides with the story. It's not as if a situation where at some point, sometime, my lawyer told me this. Again, and even that, it's still just to his mindset to why he would do that. Again, at the time, he believed that the alleged victim was going to testify that she saw him with a weapon because that's what he understood from the police report. And then he found out later that the statement attributed to her in the PSI says that she told the police she never saw a weapon and that she was intoxicated and doesn't really remember what happened. So that was the new information that he learned from the plea to then, which is the main grounds that he moved for to vacate his plea.
So Counselor, just to be clear, if in this case, there was a pretty detailed plea allocution, correct?
Yes, there was a plea allocution where they asked for specifics.
Right, and he had pled guilty on it, he admitted, then later on, he came back and alleged innocence, correct?
Correct, yes.
Okay, and the standard is abuse of discretion, correct?
Mhm.
So explain to me how we get there that, I mean, you understand what I'm saying?
Yeah, so I
It
do.
was
and
very articulate of me to.
No, I understand. This is because there's some weird things that in the order they happen, what is and what isn't on the record. I had trouble articulating it. But basically, the first thing he raised was, I think he used the term, a hearing for actual innocence and that the alleged victim lied. County court quickly said that there's nothing in the PSI that said she lied. And she didn't, say, oh, I lied to the police. What she said was, she made statements such as, I never saw a weapon, which contradicts what was previously attributed to her. And trial court just simply dismissed it as saying she never lied and never went through how those statements didn't contradict what he would have believed. But also we raised a couple other points, some deficiency with the plea colloquy, where they never addressed the issue of his right against self-incrimination, and combined with the fact that they never, on the record, confirmed that he discussed the consequences of the plea with his trial attorney. And here, obviously there's plenty of case law that says it's not necessarily a fatal flaw. In this case, combined with the other things, and the fact that he was only 23 years old facing his first felony conviction, I feel that in this case here, it would warrant it to vacate the plea. And the other ground was the issue of the discovery waiver, and especially here, where in the arraignment and even earlier before he entered the plea, he was complaining that he didn't know what the evidence was against him, that he didn't feel there was any evidence, that he appeared to be dissatisfied with the discovery. But then after the allocution, the court addressed the defense counsel and never addressed Mr. Dibrango regarding his satisfaction with discovery or his attorney's performance.
We'll take a look at that.
Thank you.
Counsel, thank you.
Good morning. Michael LaBella on behalf of respondent, people of state of New York. I would simply note, I submit the record here. It actually seems rather clear. It gave an opportunity for the defendant to speak to his attorney. They were able to, they spoke in the back. There was some back and forth where he was showing concerns over, it's like of the allocution regards to making sure he wasn't, pleading guilty to any type of attempted murder, but the judge there was at the trial level was able to, correct him and be like, no, don't worry, it's not attempted murder. You're pleading to a criminal possession weapon second. and of course lays out, is that really what you want to do? And he goes, well, like, well, I don't think I have a choice. And county court still goes and corrects further to have another dialogue excuse me, correcting and going, oh, well, no, you have a choice. You have these options. These are the options. So, I mean, it shows I would submit that really shows a intelligible choice from the defendant's side. He had a chance to go over with his attorney, the facts. The record also showed that the attorney had stated he'd gone over discovery with him before entering this plea. And then on top of that shows that he had a chance to go over his options. While he may felt constrained that he didn't have many options, which was either accept the deal or go to trial, he had stated, I wanted to plead guilty to this and chose to not do a trial. I would see that there was, between that, he allocated to the elements. I feel all in all, there seems to be little to debate in a way as regards to what was actually the voluntariness of the plea and more of how he felt about it. And then wanted
And I mean, the conversation between counsel and the defendant, to the extent that resulted in conversation that you could be charged with attempted murder, that's not in the record before us. And that could be, a subject of a 440 proceeding.
correct.
Yeah, but that's not before us today.
No,
We don't have that in the record.
That conversation had taken in the back is not in the record. Certainly, maybe a 440 could be done to explore that as well, to have each trial attorney go over what he had mentioned, but I would concur with that. And unless the court has any other questions, I would rest on my papers.
Thank you, counsel.
Thank you.
Next case, 431, People versus Coleman. Counsel Graff, can you hear us?
Yes, I can hear you. I'm unable to see you at present.
We can hear you very well. Counsel Jordan?
Yes, Your Honor, I can hear you.
And we can hear you very well. Please proceed, counsel.
May it please the court, Robert Graff for Mr. Coleman. Your Honors, in the last term, the court issued a judgment on the McKenna's case, co-defendant's case, and what the court found was that the trial court committed reversible error or committed error by failing to give the circumstantial expanded charge. As was requested, the court found that there was no direct evidence of guilt. What the court found there was that there was overwhelming evidence of guilt of Mr. McGinnis. Therefore, the error was not a fatal one in the case.
Your position, counsel, is that that was a co-defendant, but that facts in the cases they apply to you are different relative to harmless error?
The facts are certainly different, Your Honor. In the co-defendant's case, Mr. McGinnis carried his phone sort of right into the crime scene, and they were able to track him every step of the way by his GPS and by his Google and that sort of thing. With regards to Mr. Coleman, the people's evidence, Your Honor, basically is that for the November 9th incident, the first in time robbery, there were some phone calls between Mr. McGinnis and Mr. Coleman. Mr. McGinnis was tracked as going to Mr. Coleman's apartment. I'll call it apartment complex because there was 14 separate apartments in the building. And he parked outside that building for a while. And then he drove into the city and was traced to the area of the reported robbery. The people wanted to argue that he had picked up Mr. Coleman when he stopped at his house. There is no proof of that at all. He just stopped at the building where Mr. Coleman and a number of other people resided. The people argued that Mr. McInnes didn't know anyone else in the building because they said that they had not traced any of his prior phone calls to any of the residents listed on the residence schedule. Well, certainly there can be other people in the apartment building who are not, known to be living there, who don't give their phone number, who are unregistered, that sort of thing. Anyway,
Counsel,
McInnes is
counsel,
the area
like-
of the crime. And
Counsel,
at that
counsel.
time,
Mr. Graff.
Yes.
Mr. Graff,
Yes.
there's a question.
Sorry, I know you mentioned before you couldn't see us on the screen. Maybe that's where the confusion was. I sorry to cut you off. I just wanted to ask you about, because I knew you were getting into, whether he could have, the idea that whether he could have picked up someone different in the apartment complex. Is there any evidence at all in the record, surveillance video or anything, that when the co-defendant, McInnes, got to the apartment complex, that he was alone? Or whether he had a second person, perhaps the
There's
second
another
person
point.
that we see in the surveillance video with him?
Yes, he could have come from Buffalo with somebody. There's no evidence that he was alone when he arrived at the apartment complex. There's no evidence that he picked up Mr. Coleman. Mr. Coleman does make 2 phone calls near in time to the robbery from somewhere in the city of Niagara Falls. That's about all that can be said about that, because the calls are traced to a cell phone tower, and the tower is on the preparation from the People's Witness. There's a little map, and it shows like a pie shape going out with over a couple square miles of area that the tower covers. So certainly this is not proof that he was with the defendant at the time of the crime. Dealing with the 21st events, the same thing. There's some phone calls between them. McInnes drives to that residence where, the people argue that he picked up the defendant, though there is no proof that he did that. And then McInnes is traced to the scene of the first shooting and to the second shooting. And there's no information at all with regards to Mr. Coleman at that time. And there's no phone records or anything of that nature. And then and then afterwards, Mr. Coleman makes 2 phone calls from somewhere in the city of Niagara Falls, which people argue was, well, him going over the scene to check out the crime scene. But, all they can say is that he was in the city of Niagara Falls after the crime. That's basically it. So my argument is certainly this is not overwhelming evidence of guilt. There's no, the other panel found that there was no credible evidence coming from the videotapes, couldn't see faces. There's no overwhelming evidence of guilt, so I would argue that the error was reversible. Secondly, I would argue that if a jury had been properly charged with the expanded circumstantial evidence charge, no reasonable jury would have found guilt beyond a reasonable doubt. There were so many things here that the people relied on, sort of speculations, circumstantial piling of one circumstance upon another, that a reasonable jury would not have reached the conclusion of guilt beyond a reasonable doubt. And that's basically my argument, Judge.
Thank you, counsel. Counsel?
Your Honor, may it please the court, Laura Jordan on behalf of the Niagara County District Attorney's Office. Obviously taking into account the court's prior decision on the co-defendant, what I would submit is that there was in fact overwhelming evidence in this case. There was no significant probability that this defendant would have been acquitted had that full circumstantial evidence charge been read. A partial circumstantial evidence charge was read. You had these 2 individuals on both of these occasions communicating with each other throughout the day. This defendant, the co-defendant, leaves his home in Buffalo, drives across the Grand Island Bridge. The first thing he does when he gets across the bridge on November 21st is he texts this defendant. He goes directly.
The co-defendant's his uncle.
Yes, yeah, they're related.
This is an uncle from Buffalo, arguably visiting a nephew in Niagara Falls when he's going to Niagara Falls, perhaps for nefarious purposes. But that's the situation. It's not just a person in Niagara Falls, right?
Correct. Yes, they are. Yes, there is a relationship there. So he goes to that apartment complex. The detectives in this case pulled all of the roster of the people that lived there. The co-defendant was not Facebook friends with any of those individuals. They looked at his phone records. He did not communicate with anyone else who lived at that apartment complex except for this defendant. Our argument obviously is they get in the vehicle. You can see very clearly from the co-defendant's phone records, they traveled to the Bridgeway Market on November 21st and then to 7-Eleven. Understanding that the court did not feel that those videos were direct evidence, but even as circumstantial evidence, I would submit to the court that they did show very clearly these two individuals, these two African-American males who matched the description of Mr. McInnes and Mr. Coleman. You could see the height markers on the door at the 7-Eleven. You could see the difference in their builds. And
Counselor, did your office object to a full circumstantial charge at trial?
I believe so, Your Honor.
And why would you do that?
The video itself is very, very clear video. Understanding, of course, that they are masked individuals, but otherwise, you have to understand this jury had the opportunity to take a look at these two defendants for the 2.5 weeks of the trial. And I believe the court.
Counsel, you would then disagree with the court in the transcript on June 15th when the court said, I don't know how anybody could identify an individual from that video. The perpetrators were all masked. And then at page 19, I don't think anybody can really identify a person with certainty from that video. You disagree with what the court said when the court reviewed the video.
I do. The court disagreed with itself, Your Honor. It did initially state that. However, after watching the videos during the trial, after the court was able to observe these individuals throughout the 2.5 weeks of the trial itself, the court actually changed its tune and said that they believe that they have the same gait, the same posturing, I think was the language that was used as the two individuals in the video, which is why the trial court believed that the video itself was direct evidence. So even if the court isn't, obviously wasn't willing to go that far, I would submit that it is very strong circumstantial evidence as far as being able to identify these two individuals. I would also note when co-defendant drove his vehicle.
So let me kind of follow up on Justice Greenwood's question. If you have a case that you feel is so strong on the circumstantial evidence, and you even think that in your view, the video is direct evidence, why, if you're so confident in how strong that evidence is, why would you object to the full circumstantial evidence charge in this case? It wouldn't impact a jury because the proof is so strong.
I understand that, Your Honor. I think looking at the case law that was in place at the time, the Court of Appeals stating that, video evidence is in fact direct evidence. Obviously, since then, with the decision on the co-defendant's case, with another case before the Fourth Department, that's been chipped away at a little bit. But at the case law in place at the time was that video evidence is direct evidence. The only case that had gone the other way, Exford by this court, that dealt with, a grainy video where it was hard to see what even occurred in that case, how a fire was started, versus in this case, you can see very, very clearly the robberies and the murder take place. So for the case law that was in place at the time, I think that was the, appropriate charge.
But that still doesn't, with all due respect, that does not answer my question, I don't think, because even if you thought that there was a colorable argument that the video was direct evidence, and you feel that the case against the defendant was so strong, why would you argue against the full circumstantial charge? Because if you're that confident in that proof, then the jury's not going to change their mind based upon the charge. And if you're concerned about the charge impacting the jury, doesn't that really tell us that you're concerned that this is just a circumstantial case and it may be a problem?
Well, I guess just a circumstantial case, Your Honor. what I would submit is a very strong circumstantial evidence case.
Okay. All right.
I just would also note, Your Honor, in continuing with the evidence, when the vehicle went back to this defendant's apartment complex, the door that he was dropped back off to was a door that only someone that was a resident of that apartment would have a key to get back into. And also the communications, I think this court in other cases that I pointed out in my brief, where there was cell phone communication between two individuals that stops during the commission of the crime and then picks back up again, can show proof beyond a reasonable doubt that a defendant is guilty. If there are no further questions, I would rest on my brief for the other points.
Thank you, counsel.
Thank you, Your Honor.
Thank you.
Case 432-433.
May it please the court?
One second, just so I'm clear about what we're doing here. I have respondents submitting in this case.
Yes, Your Honors.
Are you observing?
This was an inadvertent omission on the cover page for the 15-minute request oral argument. I wanted it to be sort of symmetrical with the appellant's oral argument.
I'm not sure what you're saying. Are you here to argue?
I am here.
Oh, counsel, you have any objection to counsel arguing?
No, Your Honor. I was not expecting it as I saw it was submitted, but that's fine.
Very good.
Okay.
Then we'll proceed. Thank you.
Thank you, Your Honor.
And for future reference, if you've submitted, contact the clerk's office if you think there was a mistake and that you want to argue, so that you give the court advance notice that you'd prefer to argue, and then we can take care of this before argument. We don't have this dialogue. Okay. Very good. Proceed, counsel.
May it please the court, Jeff Stravino from Hodgson Russ on behalf of the appellants, the town of Lancaster, the town board. I also have with me my colleague, attorney Cheyenne Freely, who's worked with me on the case. At the end of the day, I think this all comes down to the respondent's request is form over substance. The petition is time barred under Article 78 because the substance of their claims.
Counsel, is it as simple as this? Let me just ask this question. If I can maybe cut through it, and if I've got it wrong, you tell me. You know that you folks know the record much better than I do. We have a town board vote that's 3-2, right? That's the initial vote, as I understand it. Petitioners lose on the vote. Petitioners don't like, and counsel have an opportunity now to address this, so I'm grateful of that. Petitioners don't like the result, obviously. They were requesting a rezoning. They didn't get it. Their objection is to the form of the vote, how it came to them. In other words, there's no findings of fact, and there's other objections. But the vote is the vote. You know, the substance of the vote, what their decision is clear.
Right.
That strikes me as an Article 78 if they don't like it. In other words, if they think there's something wrong with how the legislature put it together and didn't have findings of fact, that strikes me as an Article 78. That's a 4-month statute of limitations that I think both parties agree was not met.
Correct.
Right?
Yes, Your Honor.
Is that your initial argument and your main argument in this case?
Yes, it is, Your Honor.
Okay.
And the only other two arguments then, I guess, unless any of the other justices have questions about that, are they made an argument in their appeal brief that there's a continuing wrong. That was not argued below, so that's improper. And secondly, there is no continuing wrong here because it all goes back to the June 6, 2022 vote that they're claiming, that they were aggrieved by.
Let me ask you another question. The court below made certain rulings. The legislature the town board, excuse me,
Right.
reacted to appropriately a court order. And there were other votes, right?
Yes.
And there was a subsequent resolution on this, right?
Yes, Your Honor.
Which was another denial of the petitioner's request for relief.
Yes, Your Honor.
It's a superseding event. Does that moot out this proceeding?
No, because Your Honor, we appealed both orders because it turns out, I think the procedural issue here is that the initial order was never entered. And so both orders were not entered until January of 2025. And so that's why I think these appeals are from both of those orders. And I think we've got arguments still on the underlying order, which was the initial one, and then the second one. And I guess if there's a continuing violation, is that what Your Honor? I'm sorry, is Your Honor trying to get to that?
I'm just suggesting that the subsequent decision by the board moots the current one, but you're saying that because they were all filed at the same time and they came up at the same time that it's together, and so it isn't. One doesn't moot the other one. They're both before us.
Correct, Your Honor. Yes, that's I believe. But if it is the second one, regardless, then I think the court exceeded its authority by sitting as a super legislature and basically saying, this is what you have to do now the next time, which would be the third time. And I think the case law is clear that the court cannot sit as a super legislature. They cannot. Yes.
Speaking of exceeding authority, can you comment on the court ordering the entire town board to sit to revote?
Right. Exactly, Your Honor. Thank you. I think that the court overstepped its bounds by doing that, and I don't think they're allowed to do that. There's actually case law, actually, ironically, the Zions case from the Fourth Department, which also says that a court, a town board does not have to give its reasons for, adopting a resolution. And I think that's the case here. But exactly, I think, Your Honor, that they exceeded their authority by saying what we needed to do, what our town board needed to do.
But the findings of fact usually are attributed to a zoning board more than a town board. Isn't that right?
Yes, Your Honor. So I think, though, if you're getting there, that there were some prior steps in the process before this came to the town board. It had been before a planning zoning board. There was a recommendation made, and then it was noticed before the town board. There was a public hearing that was noticed. So there were these different steps. And that's why also our argument on the statute of limitations being 4 months is because it was a quasi-legislative act.
Counsel, with respect to that argument, which was the presiding justice started with, and you just mentioned the Zions case, it seems from reading your brief and your reply brief that you're encouraging us really to disavow Zions and the precedent that it had, which was a Benderson case, I think. And interestingly, the Benderson case had both a permit issue and the zoning issue, and Benderson, but the Benderson case relied on the Second Department precedent, which we can trace back to.
Right.
So we might just have those two.
Right.
And I see the reasons that you're giving based on some of the other history as to what is a legislative action, what's a quasi-legislative action, how this was individualized.
Right.
My question is your argument that we have to disavow Zions, or is there any way to distinguish it?
I don't. Good question, Your Honor. Thank you. I think you can distinguish it. And I also think that both the 2012, Zions was from 2003, Royal Management and Young Development were from 2012. And I think in both those cases, this court, the Appellate Division 4th Department, did find a 4-month statute of limitations based on a request there. So I think that, and it's not clear to me, all of the facts of the Zions case in terms of if they're on all fours with our situation. I mean, our situation clearly is individualized. I guess you could say Mr. Zions or Professor Zions, so a former professor at the School of Management at UB, I believe concerned a wetlands issue as well. This concerns where there are 13 mixed use units and they want 40 to 60. So I think there's some facts here that do distinguish it from what we understand about Zions. And I think also that we think, and I guess Your Honor points it out in our brief, that the 2012 cases by this court, which are after the Zions case in 2003, support our position.
That's very good.
Okay.
Thank
you very much. Appreciate it.
Good morning, Your Honors. Thank you for allowing me to speak today. May it please the court, my name is Matthew Dubois. I'm here for the petitioners. And we simply ask that the Supreme Court affirm the lower court's, or the court affirm the lower court's decisions because the town was not entitled to dismissal at that pleading stage. And the orders did not actually direct the town board to approve the rezoning. It simply asks that they issue a final cognizable determination, be that a denial or an approval. And the key facts here are narrow. As we discussed, WKP accepted and considered a rezoning application to rezone the subject property from light commercial, which it was inadvertently rezoned to, even though it was already multifamily in nature, to multifamily mixed use. The town planning board moved the entire process through the secret process, issued a negative declaration, recommended approval of the rezoning application. The town board then held a public hearing and put the approval resolution to a roll call vote, which, as you know, did not succeed. However, we would posit that this is not the same thing as issuing a denial. Failing to pass an approval motion is not functionally or procedurally equivalent to passing the opposite motion. For instance,
Can you remind me what the inadvertent zoning was again?
Yes,
it is in the record, and what does it say? What exactly happened that it was inadvertent and a mistake and all that?
Yes, so this property had previously existed as multifamily with 13 multifamily units in it. At some point after it was operating in that way, the town board rezoned it to light commercial, which created a non-conforming use because multifamily was not permitted in light commercial.
But they had a new comprehensive plan, right? Isn't that what happened? Wasn't there a new comprehensive plan and then they rezoned the town?
Yes,
But that's not unusual to rezone and all of a sudden have a non-conforming use. It happens all over the state.
Right, but as the petition set forth, the multifamily mixed use is fully compatible with the amended comprehensive plan.
No, I understand that it's compatible, but where in the record does it show that it was inadvertent or a mistake that because they had a plan and it looks like they followed it. So I know that your position is that it was a mistake or inadvertent, but where is that? Is that acknowledged by the town?
I guess I don't know.
Commissioner from the town say, "Oh, this was a total screw up." I don't know where that really came from.
I guess I don't have that exact site at my fingertips, but I think whether it was inadvertent or not, I think is secondary to whether or not it was properly denied the rezoning application.
Well, that's a different issue, right?
Right. Okay. So I think at the crux here, we have to ask, was the rezoning application denied? Or was there actually a final action taken by the town board? If there was a final denial by the town board, then we have a legislative decision. As the Fourth Department cases, Zion, Spenderson, and numerous other departments make clear, when there is a decision on rezoning, whether it's approval, whether it's denial, that is a legislative decision that is reviewable under declaratory judgment under the 6-year statute of limitations.
It seems like you're making separate claims, though, as part of maybe the first cause of action is that you do claim that some of the problems were procedural, the lack of the findings, or the fact that they only voted against approving the application, not a vote to specifically deny. So that sounds procedural too. In the reply brief, the petitioners cited ADM LLC, where it looks like we in 2012 addressed that distinction. We said, well, the substantive challenges, which may be, substantial relationship to public health, et cetera, that might be proper for declaratory judgment, 6-year statute of limitations, but the procedural challenges are still time barred because that would have called for an Article 78. What's your reaction to that case or that argument?
Well, at bottom, the petition that was filed here was not about the procedure and the way the decision was issued. The declaratory judgment action in this matter asked the court to find that the failure to rezone was a confiscatory and a constitutional legislative act. That the main crux, the substance of the petition was not to ask the court to find that the procedure followed was improper.
What was the declaration you were asking the court to make?
That the legislative decision to fail to amend the zoning map was unconstitutional, confiscatory, and a violation of due process. That was the bottom ask for the declaratory judgment action.
Okay.
The argument being that you have 13 residential properties here, and therefore it needs to be changed to multifamily residential use, even though the intent is to then make 40 to 60.
That's correct.
Any further, Council?
Yeah, I guess I would clarify that we have a fork here, a fork in the road. Either we had a final legislative determination not to rezone, which would be reviewed under declaratory judgment with a 6-year statute, which was timely, or we had no final determination made whatsoever, just a refusal to act, essentially a failure to pass this rezoning resolution. In which case there has not yet been a final determination, which is what we sought, what the court ordered them to produce, the town board to produce, which it did not comply with the amended order to meet with the full board present. So it has not produced the final determination and the statute has not run. We feel the continuing wrong doctrine does apply here, but you don't need to reach that. There is case law suggesting that the point at which a case becomes, the administrative action becomes final and the case is ripe for review is the point at which there's no further amelioration to be had from seeking administrative redress. In this case, the appellant petitioner reached out numerous times over the course of months, trying to get the town board to put this back on the agenda to pass a final determination, issue a denial resolution, approve it, anything other than failing to pass an approval. And it was ignored. So the final time that they reached out was October 12th. The petition was filed February 10th, which is within the 4-month statute of limitations, even if we were to agree that this is an Article 78. It is not an Article 78 statute of limitations, at least as to the declaratory judgment claim, because you cannot import a shorter statute of limitations under the sort of recasting doctrine of the cases we've put forward before you, if the case was not amenable to being resolved through a proceeding with a shorter statute. The availability is key to importing and recasting a declaratory judgment claim with a shorter statute of limitations. And as Benderson, Zions, and other departments made clear, that's not available here.
Very good. Thank you, Council.
Thank you. Hold up here.
Case 434 in the matter of James Allard versus County of Steuben. Proceed, Council.
Good morning, Your Honors. May it please the court. I'm Nick Cortez from Coughlin and Gearhart here on behalf of the County of Steuben. This case, in our view, focuses on a very discrete legal issue with what we believe to be a very straightforward legal analysis, which is whether the County of Steuben's local law number 11 of 2023 was validly enacted. And in the record, you'll see from the petition and also from counsel for petitions admissions in the hearing that was held pursuant to CPLR 7804, that there's no dispute that the law was validly enacted from a procedural standpoint. Further, there's no dispute, and again, counsel for petitioner conceded at this hearing that the local law, that the legislature had the legal authority to enact the local law. So we have a local law that either through concessions or through the uncontested nature of petitioner's papers is procedurally proper, constitutionally valid on its face, and in truth, that should end the analysis. However, throughout the course of these proceedings, both before Supreme Court and what I would presume would be here before this court, petitioner has attempted to muddy the waters by arguing.
That's the bad faith argument.
Correct.
Right? And you say that doesn't even come into play here.
That is correct, Your Honor.
Yeah.
Yes.
Even if it happened, even if it was demonstrated, it doesn't matter.
That is correct, Your Honor. Yes. And that's all based on many, many decades of United States Supreme Court precedent, which has been cited with approval by other New York State courts, most notably United States versus O'Brien, which states, quote, "It is a familiar principle of constitutional law that this court will not strike down an otherwise constitutional statute on the basis of an illicit legislative motive." That means exactly what you've said, Your Honor, which is that even if this record was rife with bad faith, which I would submit to you that it is absolutely not, that would not matter. Because at the end of the day, The law was procedurally proper in its enactment. It was constitutional on its face. And therefore, the courts cannot invade the providence of the legislature by essentially judging the wisdom of a local law if it's constitutionally valid on its face. If the court were to do that, it would be violating the separation of powers doctrine and essentially sitting as a super legislature that would judge the wisdom of any particular legislative enactment. And I would submit to you that if courts were able to do that, we probably wouldn't have laws in this country. Because any special interest group or any person that didn't like the outcome of a particular enactment.
So you think we have plenty of work to do on our own? We don't need to be doing their work?
I think that you said it perfectly, Your Honor. Yes. Now, I do want to touch on the cases that petitioner and Supreme Court both cited in their papers and in the Supreme Court decision, which purport that bad faith is somehow a relevant consideration. None of those cases deal with a traditional legislative enactment. They all deal with administrative decisions relative to employment decisions or relative to a eminent domain taking. The closest that they come to coming up with a relevant point in that regard is they cite to cases that deal with the special facts exception. And the special facts exception only applies in the land use context. I found no cases where it applies in any other context besides that. And the special facts exception applies in the scenario where an applicant applies for some kind of land use permission that they're allowed to have, and then a zoning board or a planning board delays their determination on that to give a town board or village board the opportunity to pass legislation to essentially circumvent their application. And under that circumstance, the remedy is for that petitioner to have the benefit of the older language of the zoning ordinance that predates the amendment. But what you'll notice, even from the special facts exception, is that the remedy is not to invalidate an otherwise validly enacted zoning amendment. The remedy is to give that special benefit under that special circumstance. It doesn't apply in any other circumstances besides that. Those are all the cases that petitioner cites. Those are all the cases that Supreme Court cites. And I would submit to you all that all of those cases are totally inapplicable to the present situation.
Counsel, I note that you do go to some lengths to establish a good reason or good reasons for the enactment of this legislation.
Yes, of course, Your Honor. And that's because that exists in the record. And I mean, even if you were to consider this bad faith argument, which I would strongly submit to you that you should not, even if you did, there are plenty of good faith reasons for enacting this law, namely that the legislature decided that it wanted to repeal the previous indemnification that it provided to the sheriff, which, by the way, was completely gratuitous in nature. Under the public officers law, there is no obligation to indemnify a county sheriff. That's not a matter of statutory interpretation. That's not a matter of case law interpretation. That's said expressly in public officers law, section 18.
And by withdrawing that with the new law, local law, the county could arguably be limiting exposure.
That's exactly correct. And as I argued,
so that's a financial decision.
Correct. And as I argued in my brief, Your Honor, that's exactly the reason why the county legislature did what it did. And without getting into the particulars of the sheriff's various missteps over the course of the last several years, there is plenty of evidence to indicate that the taxpayers of Steuben County could potentially deal with liability that could be easily avoided by the repeal of this law, which is what happened as a result of liability incurred from the sheriff's missteps over the years. Again, it's not worth getting into those specific details, but it's all in my brief. It's there for you to view, and certainly plenty of record evidence that speaks to that point. Now, before I conclude, I do want to touch briefly on the motion that we made for sanctions and attorney's fees in this situation. And to me, based on my previous argument, I feel like the argument with respect to attorney's fees should be self-evident. This is a case where a cause of action that is completely inapplicable was the sheriff's only theory of this case, the only one. Constitutionality was never contested. Procedural propriety was never contested. This is only based on an argument of bad faith that does not apply and cannot apply in a scenario that we have here, where you have a traditional legislative enactment that's constitutional on its face. To me, this is the reason why the regulation exists that defines what frivolity is. This is the reason why frivolity is sanctionable conduct and provides the opportunity for a successful applicant for attorney's fees to obtain them. And unless the court has any, oh, yes, sir.
Just on the last point, I mean, there was also a challenge to an additional resolution that required the sheriff to purchase his own insurance. Then that was withdrawn.
Yes.
But that was part of this when it was initially commenced. Should we consider that with respect to the argument for sanctions?
Well, in the first instance, Your Honor, that's not an issue on appeal, and it wasn't an issue by the time that we got to the end of the case before the court. But you're right, it was initially in the petition, and it was mooted by the fact that the county rescinded that resolution. If you have no further questions, I'll rest on my papers.
No further questions. Thank you, counsel.
Thank you.
May it please the court, I'm Carly Bolaños for petitioner respondent Sheriff James Allard. This appeal to us is concerning. Obviously, we do believe the record was rife with bad faith. It is a very unique case where we established a record of a series of actions that were bad faith on the part of the county.
Council says we don't get to bad faith.
Right. I disagree. I think that the council's trying to use O'Brien to wipe away the New York precedent that allows this court to review whether or not the legislation was enacted lawfully. For us, the case isn't at all, like council said, about whether the county can revisit someday the sheriff's indemnification. Of course, it may. We're not asking for super legislation. The Supreme Court's decision, I think, expressly stated that the issue remains free to be readdressed. This case is about whether the county can use its power as a targeted punishment against a separately elected constitutional officer after they threatened to do exactly that.
Your argument is that the local law that removed the indemnification, that law did something substantially. That is, it took away the indemnification from the sheriff, right?
Correct.
That's the substance of the law.
Correct.
You're saying that was wrong.
That was enacted in bad faith is what we're saying. We're saying.
Don't we have to distinguish between the substance analysis and maybe a procedural analysis for us to get to it on a procedural basis as opposed to substantive? That your opponent's arguing, I think, that as soon as we delve into the substance, what the legislature was doing, their act, not how they went about it. Maybe there was some way they went procedurally went about it and they did it wrong. But the substance of the act, which is what you need to get to, I think, to make your argument, we're outside our realm.
No, because it was the substance also that was the bad faith. So we showed, I think our timeline is the best evidence. We showed that starting back early on in 2021, the legislature threatened to do exactly what it later did. It said, Sheriff, we're going to take away, we can't discipline you, but we can control your budget and we can take away your indemnification. And then it set about to do exactly those things.
So if in fact you're right, then in any legislative action that results in a local law, if a legislator or group of legislators that were involved in the passage of that law, argument can be made they were acting in bad faith. They weren't doing it for the reasons they were saying. They were doing it for other reasons. Then that act could be challenged before us, and we could, like a super legislator, say, nope, that's no good because it's been demonstrated that there were other reasons why the legislature was acting, and arguably they were acting in bad faith, and therefore we're setting aside laws. Is that what you're saying the law allows us to do?
No, Your Honor. I think the bad faith standard that this court established in Temple is a very good standard. It's a very clear standard. I also am saying it's very difficult to prove. This record is a unique record where we established that over a timeline and showing the related various actions that took place, not one action, but multiple actions circumstantially added up to, it was like the straw that finally broke the camel's back for the justice in the Supreme Court, is that yes, this was an overwhelming amount of information that proved that there was bad faith. And then we had
Isn't there a lot of information here? Like, wasn't the legislature legitimately concerned about the sheriff's conduct as part of their equation? So they see the sheriff behave in a way that they feel will cause them harm. And that came out in the Phillips Lytle report that they relied on, correct?
So
No,
they
but
claim
you answer that yet? That's correct, right? Because I'm on my way to a further.
um,
That's true, isn't it?
so they relied on the report
Isn't that true?
before it was issued. So they
Okay.
prejudged,
Okay.
and that was part of the pretext that we showed.
They had this conduct of the sheriff that they didn't even need the Phillips Lytle report, maybe because what the sheriff's doing is kind of public information. They knew what was going on. They were concerned about it. They're concerned about the liability of the county. So while it may also be true, and the record establishes that it is, that there were some threats to the sheriff that we can control your budget. Okay. What if both are true? Okay. So they're concerned about the liability and they threaten the sheriff. They can revoke the local law. And how are we supposed to, aren't we exceeding our authority if we then go ahead and say, okay, we're setting that aside because some legislators may have had motives that were not correct, but they do have a right to protect the taxpayers of the county.
I think that what we showed is that in a case such as this, which is a unique record that shows a series of improper actions and pretexts. So they say that they relied on this sexual harassment case, but they were actually just waiting for that to occur. We showed in the record that years prior, they did legal research on whether they could take away the sheriff's indemnification. And I argue that they actually did not prove anything of the sort in terms of whether or not they actually had a sound business reason for the transaction. They never proved that they did. They say it was for the purposes of finances and economy, but actually what they did, I think, exposed the county to more liability.
Okay, but this is what's confusing to me about what the lower court did. Okay, so then the lower court is basically saying, but the legislature can later on address this again. How does that even work? So because some of the legislators may have made public statements or statements to the sheriff saying we're gonna punish your budget. Okay, but later on they can still revoke the law. When? I mean, there has to be a certain time that they can go ahead and revoke it. How does that even make sense?
I think so, because this timeline is what the lower court said does not show the bad faith. This timeline was not appropriate. The county attorney sent a letter to the sheriff prejudging what they claimed to be the important Phillips Lytle sexual harassment report. They had already made their decision on what they were going to do there before the report was ever issued. Moreover, what we showed at the hearing was that the sheriff's sexual harassment investigation was far more robust, far more in compliance with the state and local sexual harassment laws, and that the county's investigation was actually creating liability by botching the sexual harassment. A sheriff and a county must work together when there's cases of sexual harassment. Only the sheriff can discipline a deputy who engages in sexual harassment. The county has no power to do so. So the sheriff showed at the hearing that he asked a very good question. How could I possibly discipline my deputy on a sexual harassment record that you will not even show me? How can I take such a case to arbitration? I don't even have the underlying investigation report. Today, we still don't have the underlying investigation report. So the sheriff can't take a deputy to a labor contract arbitration. Moreover, we had issues here of the Taylor law, where in the middle of a sexual harassment case, which, by the way, was a minor case. It was not a touching, a grabbing, any kind of sexual assault. It was a minor, though important, sexual harassment matter. And the sheriff conducted a thorough investigation, which he had always done, and he had worked cooperatively with the county's lawyer. During the middle of that process, the county decides it's going to change its sexual harassment investigation process. No negotiation with the union, no discussion with the sheriff whatsoever. And we used that to show that the county's claim that it was trying to help the county save money, avoid liabilities, was actually creating liability. This county administration, less so the legislators, was really one legislator in the record that we showed bad faith
Counsel,
related to.
let me interrupt you for a
Sure.
second. The idea that you could demonstrate potentially that a legislative body made a determination based upon the fact that they were going to withdraw the indemnification because they viewed that as an opportunity to save money. The reason that you can now make an argument that maybe they weren't going to save as much money as they thought they would, they might have even exposed it to more. How are we supposed to evaluate that in terms of what this case is all about?
We're asking you to evaluate all the timeline and the bad faith actions that led up to the enactment of that. That what the county did was in bad faith, that it didn't have any, appropriate intention in terms of stripping the sheriff of his indemnity. It was related to its personal feud. And I think the Lando deposition was important in that regard, because in an improper executive session, she says that they were basically threatened and told that they could be sued if they didn't act. It was all of these series of things that impressed upon the lower court that this was not an appropriately enacted legislation. And I do think some time would have to pass now in order for this court to act appropriately, or the county could build a record of its good faith enactment and its business reasons. The record really does not have information, nor did anybody come to testify at court like the sheriff did to show their reasons and why their reasons were in good faith. But I do believe that this court's stance in Temple is a good stance. I think it's a very difficult standard to meet. I don't think that any case can come this far. I think that we built a very solid record that showed a significant timeline of a series of acts that showed that the county and its administrators and one legislator had acted in bad faith for personal reasons against the sheriff. And legislator Lando said it herself. I think there's personal issues here that are involved with our enactment of that legislation. That's powerful. She said it herself when she was there.
We'll take a look at that, Council.
Thank you.
Thank you. Case 435, matter of Chiktoaga-Sloan Union versus Ostempowski.
Morning, Your Honors. May it please the court, Scott Horton for the petitioner appellant Chiktoaga-Sloan Union Free School District. The threshold issue in our petition and on this appeal was not frankly addressed by the Supreme Court below, which instead focused more on our ultimate public policy question as to whether in this case of serious sexual harassment that did include physically inappropriate touching, tenured public school teacher should be disciplined.
Has the respondent returned to work? Has he served the suspension?
Well, the 24-25,
right?
The 24-25 school period obviously has lapsed. At this time, there's no way for the criteria in the penalty set forth by the hearing officer to have been satisfied subject to this.
So you're saying they weren't, those criteria, the CLEs and the counseling were not satisfied?
It's not in the record, Your Honor, but no, they have not been.
Okay.
I think we could stipulate to that.
But the suspension has already occurred?
Well, the 24, he has not returned to work for the 24-25 school year. Our position is that the hearing officer's decision essentially establishes an indefinite suspension because it makes it clear that he's not to return until he's satisfied the training and the evaluation.
Is there some reason why that hadn't occurred, the training and the evaluation?
Because, Your Honor, we feel we're entitled under.
Okay. So you haven't provided that or provided the ability for him to meet these obligations?
The hearing officer directed the district and the union, just to be clear, of course, we're the Chiktoaga-Sloan Union Free School District, but we do have unions. And the teachers union was treated as a party by the hearing officer in issuing his decision, which it plainly was not.
Okay, so what the court asked you to do was to come to some accommodations for how this, when the teacher returned after the suspension, both he and the victim could get along in the same school building and how to provide a safe place for them both.
That was one of the items,
And that hasn't happened?
he's not returned.
Okay.
There've been no efforts to satisfy the additional criteria.
Yeah, just so I'm clear, the position of the school district is that he's been on suspension, he hasn't been brought back. He can't come back until he satisfies the CLE and the counseling requirements. If I forget others, I'm sorry. But until those are satisfied, he's going to remain out. And so the 1-year suspension is going to continue on.
It's more complicated than that, Your Honor, but
Okay.
it gets into facts that are on the record. But yes, ultimately, that is our argument, that that's what the hearing officer's decision.
So you need a resolution from us.
So what we need as a threshold matter is a definitive award from the hearing officer that does not rely on both the district and a third party, the union, to negotiate ultimately what we believe, given the public policy of this state, is negotiating the terms of a hostile work environment that we're going to potentially be forced to.
It wasn't a conclusive finding and direction because it said it was subject to further negotiations, and the negotiations were going to be including the union. And you have a problem with that because you're bringing a party in that's not a party to this and should not have a say in what the ultimate penalty is, or the ultimate, maybe not use penalty, but the ultimate resolution of this is relative to the CLEs and the counseling and that kind of thing.
I actually use the term penalty myself, Your Honor, except that is the label that the hearing officer's decision put on it.
Right,
So in that context, we can refer to it as the penalty. But yes, section 3020A of the education law compels the district to use this procedure if it wants to impose discipline upon a tenured teacher. It relied on that procedure. And at the end of the day, the hearing officer said, at a minimum, he's not returning to this school year. He may be able to return at some future point if these other criteria yet to be established are satisfied. But even without bringing in the union and just relying on telling the school district to determine what the standard would be to return, and even that in of itself would be an indefinite award that's beyond the hearing officer's purview. But certainly requiring the district to go out and negotiate with a third party, which, oh, by the way, in this particular instance, happens to be a union that both the perpetrator of harassment, the respondent, and the victim, a fellow teacher in the school, belong to the same union bargaining unit, puts the union even
complaining about it. Has the union balked? As the union says, we're not willing to help make this work out?
No, the union has not objected to that because they want to enforce the hearing officer's award as written.
And is that what they've communicated that to you? We won't be part of this negotiation because we want to make sure that this award is followed out as written.
Again, Your Honor, I don't believe that's in the record, but again, I would not be able to make a representation that the union has communicated that they would not be party to such discussions.
In reality, we try to do this without the union, okay? Arrange something to make both of these teachers safe in the school building. How does that work without the union?
Well, the district's position is it can't work in this situation at the end of the day. There's no way to sufficiently separate Mr. Ostankowski from the victim.
You have more than one school, I imagine.
The high school and middle school are both in the same school building. It's a small district, and both of these teachers are.
And there's interplay between the students and the teachers back and forth between the middle school and the.
There's various levels of interplay. At one point in time, as referenced in the record established in this case, there was a shared principal for the two buildings. They went back away from that, but clearly there is interaction between them. Students do go back and forth during the school day.
And your ultimate position is that you can't make, under these circumstances, there's no way to make a safe environment for the victim here, if the employee is coming back to work.
That is our ultimate position, and we feel that that's inconsistent with the state's public policy. We recognize that Your Honors don't have to reach that at this point in time, but we do feel it's relevant to understanding the outcome of this case, which at a minimum we feel requires a remand to the hearing officer to give us a final definite circumstance of the penalty being imposed so that we can then as a district impose the penalty. But we do feel that if the hearing officer ultimately were to do anything that required the reinstatement of the respondent, then it would put us in the untenable position of effectively having to place our other teacher in a hostile work environment, separate and apart from what it may do to
What's your
others.
position on this? Can we rule that you're right, having the union participate in this as a non-party is inappropriate? And modify the hearing officer's determination to remove the union from that dialogue, allowing only the school district to then make the determination as to what the CLE is and what the counseling requirements are?
My interpretation of the interplay between section 3020A and section 7511 of the CPLR suggests that you don't directly have the authority to modify the award. You'd have the authority to vacate with directions to the hearing officer how he can properly revise his reward or award to satisfy his statutory obligation.
And that's what you're asking us to do.
Ultimately, that's what we're asking you to do, particularly to remand with instruction that he satisfied both his statutory duty under 3020A and issue an award consistent with public policy against sexual harassment in the workplace.
His suspension in excess of a year, is that paid suspension? Or have you been not paying him for more than a year?
Yeah.
That's
I
an
just
easy question.
apologize, Your Honor, because you're asking me questions that are not in the record and
Well, you're telling us about things that are impossible, and I'm trying to figure out whether or not the school district may have exceeded its authority by keeping him out of the school in longer than a year, for longer than the 1 year that was imposed.
I can indicate, and you're welcome to ask
I will.
my opposing counsel, but I can indicate there is an arrangement in place agreed upon between the parties to account for the situation.
Okay, so I'm not getting that. I mean, have you resolved this issue short of you being here?
No, Your Honor, the question is definitely ongoing. There's a contingent understanding that will depend on the outcome of the court's decision in this case.
Very good. Anything further, counsel?
No, that's all, Your Honor. Thank you.
Good morning, Your Honors. My name is, and may it please the court, my name is Jenna Burke. I'm of counsel to Robert T. Riley. I'm here on behalf of respondent Mark Ostenpowski. We are here because the district simply disagrees with the penalty imposed by the hearing officer because it wanted a penalty issue that was nothing short of termination. The lower court did not abuse its discretion in declining to vacate an arbitration decision. The challenged decision of the hearing officer did include findings of serious misconduct. The arbitrator did sustain all 4 disciplinary charges, and he did impose a particularly severe penalty, which consisted of a 1 year unpaid suspension, mandatory sexual harassment training, a psychological evaluation, and workplace separation conditions. Disagreement with a penalty determination is not a basis to vacate the 3020A arbitration award.
Is it fair to say that if that's what the hearing officer actually did, in other words, if the hearing officer actually did that and set forth those requirements without adding the additional fact that these are going to be negotiated between and bringing in a third party, that we wouldn't be here?
Well, I don't know if that's correct, Your Honor. We may still be here. The district does argue that the hearing officer exceeded his authority because portions of the award contemplate cooperation between the district and the union regarding the implementation of remedial conditions. But this argument fails. First, education law section 3020A expressly authorizes remedial measures in addition to suspension or termination. The statute is very broad in what it allows a hearing officer to impose as various conditions. It authorizes specifically counseling, continuing education, medical treatment, and any other remedial actions. And the award is final and definite. It tells what the remedial actions are. It leaves the details, to be determined, what coursework, what doctor the respondent will go to, how many hours of coursework. It does leave those details unresolved, but the hearing officer wouldn't know which doctor to send the respondent to.
But if the hearing officer simply made the same determination and simply left it to the school district to fulfill that.
He could have done that, but he's not required to do that under the statute.
Well, that's the issue before us, right?
That's one of the issues before you, yes. But I would submit that the award clearly resolved guilt and it clearly resolved the penalty. It just left the details to be determined.
And those details were put in place for the protection of this victim. And the school district.
I think they were put in place, right, so that there would, the details of which doctor, who should the respondent go to for the psychological exam to be conducted, was by agreement by the union and the district. The details of which specific sexual harassment course to take, those details were left to the parties to work out.
Not the parties.
Well, the union and the.
I think that may be ultimately a big distinction. But there are occasions, I suspect, where a union and a school district can't reach agreement on things. Would you agree with that?
I would agree that there are occasions, but in this particular circumstance, the idea that there could be possibly speculatively a disagreement as to the details doesn't render this award to be not absolute and final. It's speculative, and I did cite a case regarding. Let me just get to the site. This is a matter of Niagara Falls Captains and Lieutenants Association, City of Niagara Falls, and that is a 4th Department case. And there was an award that directed the parties to do something within a reasonable time frame, and the parties were looking to that there was no definition of what is a reasonable time frame, and the idea that there could be disputes over what is a reasonable time frame in which an event to happen, and the 4th Department did find that is not enough to overturn.
Do you have a similar case where it's including a non-party?
I do not, no.
Okay. Any further?
Well, do you want me to address the remaining issues with regard to public policy?
You can feel free to do so. Yep.
Okay. So the Court of Appeals has repeatedly held that an award may be vacated only if it violates strong public policy, is irrational, or clearly exceeds a specifically enumerated limitation on the arbitrator's authority. Here, the award was plainly rational and fully supported by the record. Hearing officer conducted a 2-day hearing. Record shows he heard testimony from complainant, administrators, co-workers, and the respondent himself. The record shows that the hearing officer expressly considered the seriousness of the conduct, the impact on the complainant, the respondent's remorse, his willingness to undergo corrective measures, and his 25-year discipline-free employment history. And with regard to the public policy exception is exceedingly narrow. A vacature on public policy grounds applies only where there is an explicit conflict with law or an absolute prohibition against the relief granted. There's no statute here. There's no controlling precedent. There's no public policy in the state of New York that requires mandatory termination for a single incident of workplace sexual harassment under Section 3020A. In fact, the cases cited by the district recognize New York's strong policy against workplace harassment, the policy that the hearing officer did fully acknowledge and enforce through the substantial discipline that he did issue. The hearing officer did not excuse the misconduct. He didn't minimize it. He did impose severe consequences. And the district's argument with regard to public policy ultimately asks this court to adopt a rule that termination must always result whenever sexual harassment is substantiated. So in conclusion, the lower court below exercised its discretion in denying the petition to vacate because the award was rational, it was supported by the record, it violated no explicit public policy, and finally, the hearing officer did not exceed any specifically enumerated limitation on his authority. The district seeks is not judicial review under CPLR 7511. It just wants a different penalty. It wants this teacher to be terminated. It does not want this teacher to be returned to work. It disagrees with what the hearing officer imposed after the arbitration.
Thank you. Case 436 and 437, County of Erie versus Selective Insurance Company. Mr. Sharkey, can you hear us?
Yes, I can, Your Honor. Thank you.
Very good. We can hear you loud and clear. Please proceed, counsel.
May it please the court, Matthew Ronan, Kenny Shulman Noack for the defendant appellant, Selective Insurance Company of America. Your Honors, this case or this appeal as far as Selective is concerned concerns both the court below's decision on the parties' summary judgment motions, including Selective's cross motion for summary judgment. It also addresses the court below's decision on Selective's motion to strike, which was the result of Erie County refusing to sit for a deposition. This is a contract case that concerns the single question of whether Selective's insured, which was Destro, was obligated by contract to name Erie County as an additional insured with respect to the particular paving work at Emery Park in the South Towns, where the underlying plaintiff was injured.
The lower court said this was moot. What do you have to say about that?
That was the next thing I was going to say.
Oh, okay.
So as far as Selective is concerned, and any contract case is concerned, the contract, the first thing a judge does, of course, is look at the contract. Does the contract answer the question? Selective's position in this case has been from the beginning that the contracts make clear that there is no requirement for Destro, Selective's insured, to provide Erie County with additional insured coverage with respect to Emery Park specifically. However, if the court is going to consider evidence extrinsic to the contract, which it did, if the county is going to base its whole summary judgment motion on evidence extrinsic to the contract, which it did, then Selective is entitled to depose Erie County. And so what happened here was we noticed, we being Selective, almost a year, roughly a year before the summary judgment motions were made, the deposition of Erie County. That didn't happen immediately because we were waiting for written discovery to conclude, as one does in a contract case. Once the written discovery concluded and the court below said we're going to have the summary judgment deadline very quickly, within a month or so, we were working to depose Erie County. At that point, the record shows there are emails between myself, between Erie County's counsel saying, you know, we noticed your deposition, we'd like to depose you. Erie County says no. I say, well, here's why we need to depose your witness. You're saying that not the contract itself, but all these, what you would say are ancillary documents, add up to a contractual requirement. That's your argument. That's your theory of the case. And we would like to depose your witness on your theory of the case. On those,
This particular park wasn't even mentioned in the original documents, correct?
That's correct. I think if your Honor would allow me, I'll address that kind of in point B, because there's kind of this cascade of additional documents presented both pre-litigation and during litigation. But correct, the initial contract and the documents that require additional insured coverage apply to a completely different paving project, not in the South Towns. I know we're not in Erie County here, but in the North Towns, in the Amherst area, Cleveland Drive and Kensington Avenue. And let me tell you, Kensington Avenue and Cleveland Drive is a far cry from a little, not even really a road, a little park piece of pavement in Emery Park. So counsel for Erie County, and this is in the record again, says the deposition of Erie County would be irrelevant because the documents speak for themselves. What happens when they move for summary judgment? Documents no longer speak for themselves. We get 8 pages of affidavit testimony from Erie County's witness, a project manager, explaining exactly why all these documents mean what Erie County says they mean even though it's not obvious on his face, but we never got to depose Erie County. So again, to answer your question directly, if the court were only going to look at the documents themselves, then the deposition, I guess, would be moved. But if the court is going to base its summary judgment decision as it did, if the county is going to make its case as it did about its witness's explanation of the documents, then we should have been allowed to depose its witness. And I think the problem here is very clear, and what a decision affirming the court below would do, and the dangerous precedent that would set, which is never mind sitting for a deposition, just don't do it. Just drag your feet, say no, 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 no. Make your summary judgment motion based on the testimony of the would-be deponent, and your adversary will never have any foundation, will never have any opportunity to conduct discovery to rebut the testimony in your affidavit of your witness that you refused to allow to be deposed. The other, and I guess I'm starting here with the discovery issues and not the substantive issue, because that's.
Let me ask this question. I mean, I always thought that in determining whether or not you would defend the county, it would be governed by what was in the four corners of the complaint. Okay. And evidently the complaint alleged something with regard to the client that you insure that brought this either within or not within, what the complaint says. I mean, does the complaint bring your client in or you're insured in or not? And is that something that we need to answer before you, defend and find out the answer in the course of discovery of that case?
Sure. Most duty to defend cases do address that issue, but that's part two, right? We don't get to part two. And in fact, we don't dispute part two, but there's no part one, so you don't get to part two. And here are the two parts. The additional, because the policy language governs and the contract only matters to the extent it's referenced in the policy. So the policy here says we provide additional coverage, additional insured coverage where required by contract, that's part one, for liability caused in whole or in part by your actual omissions, that's part two. We don't dispute the allegations in the complaint, in the underlying action, conceivably raise the possibility that Destro could have been a cause of the accident. But you don't get there, because the first part is we only provide additional insured coverage. Again, the policy language governs. We only provide additional insured coverage where required by contract. And so there has to be a contract in effect on the date of loss applying to the project, the paving work where the accident happened. The contract doesn't say that, right? And so pre-litigation, there's a tender from Erie County to Selective. Do they submit any documents with that tender for additional insured coverage referencing Erie Park? No, they do not. We get later into the tender, we get into litigation, then we start to see a bid packet. Is there anything referring to Erie Park in the bid packet? No, there is not. And then there's more discovery. There's a purported bid addenda or an addenda to the bid packet. Is Erie Park listed there? No. Now we get to summary judgment motion. Is there anything in the Erie County summary judgment motion referencing Erie Park? No, there is not. Where does Erie Park show up for the very first time? In opposition to Selective's cross motion for summary judgment, they provide a purported second bid addenda, purportedly applying to the contract, the Cleveland Drive, but also Erie Park, because our project manager that you never got to depose said it does. The second bid addenda that we never produced, despite the fact that you demanded all contracts related to the project, all documents related to any of those contracts, it never produced this document, the picture, this other little table. It never produced them until the opposition. I mean, it was the most plainly responsive thing.
Excuse me, why wouldn't you have that information? Not you, Selective, but you're insured, have all those bid packets. Why wouldn't that be information that you already had?
That's an excellent question. Why wasn't it in Selective's claim file? When Selective has a claim file, as insurance companies do, for the claim made by the underlying plaintiff against Destro at Erie Park, if this document was related to the Erie Park work and related to any kind of coverage issue, then probably we would have it, but we never had that, which speaks to the issue that we don't even know if Destro had this thing, right? There's no evidence in the record that Destro had this picture, the little table. at any point prior to the opposition to Selective's summary judgment motion. So the case law is very clear, apart from the deposition issue, that you cannot come in with evidence that was responsive to an adversary's document demands for the first time in opposition to a cross motion for summary judgment. The court cannot consider that evidence. That's pretty standard stuff as far as the case law is concerned. Finally, moving off the discovery, what I would call abuses by Erie County, to the substance itself, there's still, if you take everything, even the testimony, even the document that wasn't produced that the court below could not consider, it's still not clear. And let's be clear, this is Erie County's burden to show there is a clear and express requirement that Destro name Erie County as an additional insured with respect to the Emery Park work. They still don't do that. They still can't show that clear and express requirement with respect to Emery Park. The documents don't add up that way. There's no evidence that Destro ever saw this purported second bid addenda. And if you look at the legislatures that's in the record, I'll call it a resolution. Forgive me, I don't do municipal law, but I'm going to call it a resolution. That initial contract speaking to the Cleveland Drive, Kensington Avenue work was $1.4 something million, right? Erie County allocated that I think it was 1.49 something, right? It then allocated a completely distinct amount for paving work. Well, if the Emery Park work was all part of the contract, then why don't the dollars match up? And again, that's Erie County's burden to make all this make sense in a express and clear manner, and it hasn't done it. So even aside from the discovery issues, the contracts don't add up to an express requirement for Destro to name Erie County as additional insured with respect to Emery Park. Therefore, the language of the Selective Policies additional insured endorsement has not been satisfied.
Thank you, Council. Mr. Sharkey?
Thank you, Your Honor. Good morning. May it please the court, Steve Sharkey for the plaintiff, respondent, County of Erie. Justice Bannister, I think you really seized on the relevant issue here, and that is what we're dealing with here, and that is a duty to defend. We're not talking about a duty to indemnify. The court certainly knows this area of law very well, but it's suffice to say that that duty is quote unquote exceedingly broad, and the standard for triggering that duty is fairly low. As the Court of Appeals held in BPAC Corp v. One Beacon Insurance Company, if a complaint contains any facts or allegations which bring the claim even potentially within the protection covered, the insurer is obligated to defend. And I'd submit—
So, Mr. Sharkey, counsel tells me we don't get there, okay? We don't get there because there's no clear contractual obligation, that to defend, or, for you to defend.
Well, I disagree.
Okay.
Thank you, Your Honor. Yes, I disagree with that. We did submit evidence. We've submitted evidence in the form of the complaint, which clearly shows their allegations suggesting that Selective's insured Destro and Brothers caused the plaintiff's injuries in the underlying accident. We've also submitted the affidavit of the project manager who was involved in the bidding process, who was involved with this contract, and was involved in actually overseeing and watching Destro do this work. Nowhere in their submission do they refute that Destro was in the park actually doing this work, or that they provided us with a certificate of insurance. And instead, what we've gotten are these speculative and conjecture raised by Selective and its attorneys about what this work was under the bid and or the contract. But they weren't a party to these contracts, Your Honor. They have no personal knowledge of this matter. And you raised a good point earlier, Justice Bannister. That's the rub of this case. If there was a legitimate dispute about this, all they needed to do was submit an affidavit from somebody with personal knowledge, that is their own insured, who they have control over, and submit an affidavit from them saying, hey, we didn't do this. This wasn't a part of the work. We didn't bid on this. But they didn't, because, Your Honor, there is no legitimate issue about that. Had they talked to Destro, they would have told them that they were wrong. And we know that because we've participated in depositions in the underlying case where they readily acknowledged that this was part of the bid and that it was part of the contract and they did the work. So we would submit.
Okay, so that's another question of mine. There's been progress on this case. There's been some depositions. The case hasn't been just standing still waiting for us to act here.
Correct. Are you suggesting the underlying case or the DJ case?
Well, I don't know which one.
I think it's the underlying case, Your Honor. Yes,
Right.
there have been depositions extensively conducted in the last year or so, and we've had some settlement discussions as well. So,
Okay.
yeah, it has.
Counselor, you don't dispute that the contracts under litigation here, the original, don't include Emery Park, right? It's the subsequent documents, isn't that true?
Your Honor, yes. These bid documents are fairly voluminous, and I think when some of these documents were produced, not everything was initially produced. Frankly, we did not understand there to be a real dispute about this issue. So when it was raised, some additional documentation was provided to support the bid addendum that specifically related to this work. There's diagrams showing it. There's payments that we've referenced, cross-referencing this specific work. Again, we have not seen anything from Destro disputing this. The only person we're hearing from is Selective and its attorneys, and we believe it's just a feigned attempt to try to avoid their clear coverage obligations here.
But why wouldn't they be entitled to discovery at this early stage? And so,
well, thank you, Your Honor. That's a good question. I think there's a few reasons for that. First of all, when my opponent was talking about this motion and what led to it, he left out some very key details. First of all, this path was charted and agreed to by all counsel. And we've referenced this in the underlying papers. We participated in a conference with Judge Sywek roughly 2 months before this motion was heard. And in this conference, this very issue came up. And we talked about whether there was going to be a need for depositions. And all the attorneys who were present, including an attorney representing Selective, all agreed that they were not necessary and that we would proceed forward with summary judgment based on what was at issue for this duty to defend issue. And the court directed us to file our summary judgment motion based on that agreement at the conference. It was only after this conference that counsel for Selective attempted to drum up this need for discovery and filed their motion literally 1 business day before they knew the county would be filing its summary judgment motion. So we don't really think it's a serious argument. We think it's something that they knew full well. It was agreed to by all parties. And this was something raised after the fact in an attempt to try to raise issues on the impending motion. Secondly, Your Honor, they themselves have cross-moved for summary judgment. And by doing so, we don't think you can take the position that you're entitled to summary judgment. There's no need for discovery and these issues can be resolved as a matter of law. But yet, when the county moves, no, you can't rule in their favor because discovery is required. And lastly, Your Honor, with respect to 3212F, which talks about the need for facts essential to oppose the motion, they don't meet that standard. You're supposed to provide an evidentiary submission demonstrating why you need this information, and more importantly, that they're exclusively in the county's possession and control. And I'd submit here, this is where they fail in their argument, and it's flawed. They had control over the other party to this contract. If there was a legitimate issue as to whether or not this work was covered by it, all they had to do was talk to their insured. And if they did and they doubted it or disputed it, they could have very easily submitted an affidavit from Destro. The fact that they did not speaks volumes about the lack of substance of their position. So unless the court has any further questions, I'll be happy to rest on my papers.
No questions, counsel. Thank you.
Thank you.
Well, Your Honors, may it please the court. My name is Noah Wiesner, and I represent the defendant appellant Zurich American Insurance Company. This aspect of the appeal concerns whether a professional services exclusion in an additional insured endorsement contained in a general liability policy issued by Zurich to Lero engineers bars coverage to the county in the underlying action, the Voss lawsuit. The exclusion at issue precludes coverage to putative additional insureds like the county, where the claim involves bodily injury that arises out of the rendering of or failure to render professional services.
So let's go back to some of the questions I asked other counsel before.
Yes, Your Honor.
About where we get our, our baseline is what's in the complaint, isn't it?
Correct.
Okay, and in the complaint, and I'll just read a line from it. They say that Lero was negligent, careless, and reckless, and and accuse them of unlawful conduct. And they don't particularly in the complaint draw down and say it's only for the professional services of Lero. In other words, they seem to be alleging more general negligence claims against you. And you think that we should read that complaint as to only be relevant to the professional services rendered by your client?
Correct, Your Honor. And what we would point to in the complaint specifically, and that is absolutely the starting point for consideration of duty to defend. We think that this court can determine that the professional services exclusion applies if it just looks at the complaint. But we do think consideration of the contract documents are warranted here, and I'll get to those reasons later. But if we look at paragraph 21 of the complaint, the claimant in the underlying action specifically identifies Lero Engineers as the, quote, engineering consultant on the project. And it says it was hired by the county to perform work on the roadway repaving project at Emery Park. And then in the subsequent paragraphs, it ties each of Lero's duties and breach of its duties to its work in connection with that project. And so if you read the complaint as a whole and consider the broad arising out of language that's contained in the exclusion, you cannot divorce Lero's conduct, at least as it's alleged in the complaint, from how the claimant characterizes Lero, which is as the engineering consultant on the project and pursuant to the contract that it entered into with the county. So, Your Honors, going back to the language of the exclusion, as I said, it precludes coverage for bodily injury that arises out of the performance or non-performance of professional services. And the exclusion contains a non-exhaustive list of what those professional services are. And it includes, but it is certainly not limited to, supervisory activities, inspection activities, and most importantly, engineering activities. And so it's our position, Your Honors, that the lower court erred in holding that these claims against Lero that are made in the Voss action did not arise out of those aforementioned activities and similar activities, and for two principal reasons, Your Honors. First,
does the court have to make those kind of findings? Can't the court just go by what is alleged in the complaint? In other words, your first argument that the allegations in the complaint are broader, are not broader. They're actually within the exclusion.
Correct.
I guess I'm just having some difficulty because I read them as more general.
Understood, Your Honor. And part of the confusion might be the rationale upon which the lower court based its decision, which was largely upon what was required in the contract. Essentially, and again, the county in its complaint against.
So you're telling us that we need to read the contract as well as the complaint to get to the conclusion you wish us to get to.
Well, I think, Your Honor, I think there's two things. One, I think you can read the complaint alone without reference to the actual contract, and you can see, based on those allegations that I had just went through, that any liability that will ultimately be assessed to Lero is based on its role as an engineering consultant, which the claimant clearly points out. That alone is enough to bring it within the professional services exclusion. The lower court did not consider that. It looked at what was Lero required to do under the contract. The county has made arguments about what Lero was required to do under the contract, and it found that in addition to the engineering and consulting activities that it was required to perform, its requirement to perform construction management, coordination, and quality control. Those three activities somehow brought this claim outside of the professional services exclusion. So to answer the question, I think you can look just at the complaint, or you can look at the contract. And I think there's case law that says extrinsic evidence can be considered in certain circumstances. And it's warranted here because of the representations that the county has made about what Lero was hired to do.
But when the county put this out for bid, and the county said, we need an engineering consultant to do a variety of tasks here, some of which arguably are covered by the professional services exclusion, some of which are not. But when the county said, you got to add us though, as an additional insured for all the work you do, I don't care how we parse it out, all the work you do. If Lero then goes and purchases a policy where only some of the work they're doing is covered and other work, aren't they in breach to the county? Aren't they failing to get the coverage that the county required in the bid package?
Your Honor, I think you're picking up on what is typically done in these situations by engineering companies like Lero is they acquire two different lines of insurance, right? There's commercial general liability insurance, which is the policy that Zurich issued. And that frequently covers bodily injury, premises liability, slip and fall type cases, right? Professional liability insurance, which it's not clear exactly from the record whether Lero obtained that insurance, but very frequently they do. Professional liability insurance is meant to cover wrongful acts that involve the performance of professional services. And so it's very possible that Lero acquired that insurance and that if the county tendered to that carrier seeking additional insured coverage, they might qualify for additional insured coverage. But it's clear, at least from the additional insured endorsement under which the county seeks coverage under the Zurich CGL policy, that there is an explicit exclusion within that endorsement for professional services. Now you're up.
So if the county brings a claim then against Lero and says you failed to get the coverage, and the folks at Lero said, gee, we thought Zurich was covering everything. That's for another day. That's an argument that you'll deal with in whatever proceeding is brought.
Absolutely. And I'm not sure, Your Honor, standing here right now, whether the county has brought a breach of contract failure to procure claim. I just don't know. But I do know that the county has claimed additional insured coverage on the commercial general liability policy that my client issued. And what the lower court did say in its opinion was that the professional services exclusion, quote, would apply to engineering services. And so again, if we look at the allegations of the Voss action complaint, we look at the affirmative representations that the county has made about what it hired Lero to do, then we see that any potential liability that might be assessed against Lero in the underlying action is necessarily connected to those engineering services. And under New York's broad interpretation of that arising out of language, the lower court should have found that if this exclusion applies to engineering services, then this exclusion applies here. The second reason, Your Honors, is that the lower court incorrectly, again, focused on that construction coordination, construction management, and quality control services that Lero was obligated to perform under an engineering consulting contract, to say that these types of services are not professional in nature. But that was incorrect based on the case law that we've cited, Your Honors. And so first, we've already gone over some of the facts about the complaint, about Lero being identified as an engineering consultant. But again, the county has made affirmative representations about the contract and what it hired Lero to do. And we've cited numerous provisions of that contract that the county introduced in our brief. But just to highlight two examples, the request for proposal that the county contends is part of the contract said it seeks proposals for consultants for professional engineering services related to.
So
yes,
even though that's what the contract says, there could be something, don't know. But if I was to read that, the original complaint, I might be able to say in my mind that maybe they did something other than provide professional services. Maybe, they did something that was negligent or careless or reckless that falls outside of that coverage.
Well, certainly the lower court held that Lero performed, for example, construction coordination, and it held that that type of activity standing alone is not a professional service. I think we have case law in our brief that would dispute that. And again, the use of the phrase arising out of, it's a term of art when used in a policy exclusion like this, and New York courts consistently say that the question is whether the bodily injury arises out of, is connected with, originates from the excluded activity. In fact, some courts say, could the claim exist but for the excluded activity? The professional services do not need to be the proximate cause. They just need to be a but for cause. And so what we think the lower court did was it picked out certain aspects of the holistic contract and said, well, if it performed construction coordination on Tuesday and no engineering services at all, then it did not perform professional services on the project. But we think that the contract should be read holistically if the county's going to rely on it for their arguments.
Yeah.
Council, you should be mindful of your time and should begin to wrap up.
Okay, that's all I have unless your honors have any further questions.
No, now somehow Mr. Sharkey's not on our feed any longer.
He argued, right?
He did,
Yeah,
but with
okay.
regard to yours, we'll, look in we have his brief for his argument.
Well, thank you.
Okay, thank you, your honors.
439, U.S. Income Partners LLC versus Cypress Point FL Holdings LLC. Proceed, counsel.
Good morning, your honors. It's Jeremy Schulman for U.S. Income Partners. This case comes before the court on, in our view, rather striking or even shocking facts. There was an underlying litigation, which is still pending, in which U.S. Income Partners was seeking to enforce a note and a guarantee on a $10 million loan. And that loan had not been repaid because of intervening fraud by a hacker and the negligence of the escrow agent for the borrower in directing the payoff proceeds on the loan to Mexico. So while that case was pending, and all of this had to do with a apartment building in Florida, and as part of the security for the loan, U.S. Income Partners received an assignment of 100% of the membership interests of the borrower entity. Therefore, no disposition of the property could rightfully have taken place without U.S. Income Partners' consent. Secretly, without their consent, without their knowledge, the borrower sold the property for $62 million during the pendency of the underlying case. And so we think that's a very disturbing set of facts, because clearly, and we allege below and demonstrated with an affidavit, that was the sole asset of Cypress and its subsidiary, Mystic Point. So while a judgment is potentially looming, they sell their sole asset for $62 million, and then they distribute the proceeds of that sale to the underlying members but not the real member, which is U.S. Income Partners, the former members. So this is a classic fraudulent conveyance, voidable transaction. And so we brought the underlying, the new case for which we're here on appeal, principally seeking relief under the voidable transaction statute, the debtor-creditor law, DCL section 273A. So these are new causes of action, not directly relating to the underlying case, but tangentially relating to the underlying case. And then we moved for an attachment for the imposition of a receiver. And we're trying to protect against what was clearly the objective of the borrower in evading the jurisdiction of the court and rendering themselves essentially judgment proof. The trial court below, in evaluating our motion for attachment and for receivership, really applied the wrong legal test and applied the wrong legal test incorrectly. And I'll explain why. So we moved under CPLR 6212 for an attachment. And there's essentially three elements that we need to demonstrate. One, that there's a viable cause of action and the probability that the plaintiff will succeed on the merits. Two, that one or more grounds for attachment exist under CPLR 6201. And three, that the amount demanded exceeds all counterclaims known to the plaintiff. The trial court essentially only applied the first element, but applied it in the wrong manner. What he said basically was that, okay, we can't show probability of succeeding on the merits because in the original underlying case, summary judgment was denied, and he concluded that there were questions of fact that needed to await trial, and therefore you can't yet determine who's likely to succeed. That's the wrong standard, I would submit, because we're seeking an attachment in furtherance of our voidable transfer claims. So the question is, are we likely to succeed on the voidable transfer claims? Is there a probability we will succeed on the voidable transfer claims? So you don't look at the underlying breach of contract claims, which we're happy to do, by the way, and we think we are likely to succeed there as we demonstrate in our brief. But it's a much lower standard of review if you look at our likelihood of success on the voidable transfer claims. Because what does the voidable transfer claim require? This is section 273A of the debtor-creditor law. A transfer is voidable if made with intent to hinder, delay, or defraud a creditor, and the transaction renders, I'm paraphrasing, renders the debtor essentially insolvent. So are we probably going to succeed on that voidable transfer claim? Irrespective of the merits of the underlying case, we came forward with...
Counsel, I'm going to interrupt you because this is a very unusual circumstance, I think.
Usual?
Very unusual
Yeah.
circumstance, right? And so you're identifying for us two different set of facts, right? And in the first set of facts, you believe you'll be successful, but the court below ultimately determined that there are questions of fact as to whether or not a payment was made, right? And whether it was accepted, who was responsible in those factors, right? You're telling us that we need to shift our focus from where the trial court was and shift our focus to, we've got now conduct in the middle of this litigation where the party has one asset and they've sold it. And they're trying to essentially avoid responsibility for the payment of a just debt. Right? You want us to separate those two things, focus on, for purposes of applying the test, focus on just, did they sell this in the middle of a litigation to try and avoid payment of a just debt, right? You're saying we don't need to answer the question of fact as to whether the just debt was already paid. You believe you'll win on that, but you're not, who can be sure, right? It's a contested fact or contested issue. So you want us to look at just the one set of facts to try and protect the assets so that ultimately when that first litigation is resolved, there's an asset left to pay.
Correct, but it's not just what I'm asking you to do. It's what I think what the law requires.
No, I understand that, but I mean, you're asking us based on the law.
Yeah,
I get that. I'm not saying you're making this up on a whole cloth, but you're drawing a distinction here between the two actions, and the court below made a mistake by focusing on the wrong set of facts.
Correct, as the law requires.
Yeah.
I think we can satisfy even the set of facts that the trial court was focusing on, and I'm happy to explain that further, although we do elaborate on that in our brief. But the reason I think the law compels sort of the second analysis is if you just look at the language of both CPLR 6212 and 6201, which is imported in 6212, basically says you can get an attachment if you meet the requirements of 6201. And 6201.3 allows it for an assignment where the defendant assigned, disposed of, encumbered, or secreted property, and defendant acted with intent to defraud his creditors or frustrate the enforcement of a judgment that might be rendered in plaintiff's favor. might be rendered. Doesn't say probably will be rendered, doesn't say likelihood of success.
That reaches back to the first action is what you're saying.
Exactly. And the fact that actually summary judgment was denied demonstrates that at a minimum, a judgment might be entered, right? Had we lost summary judgment and the case against us were dismissed, okay, we're definitely not going to get a judgment. But if there's an issue of fact and we have to have a trial, then we might get a judgment, they might get a judgment. So we clearly, I think what the CPLR is intending to do is not allow for a situation like this. And maybe this is an unusual situation because most litigants and counsel wouldn't dare to do this, wouldn't attempt this.
But the case law also says attachment's an extreme remedy.
For
This
extreme,
is abuse of discretion standard in this case.
well, okay.
Okay, go ahead.
Sorry,
No, go ahead. Go ahead.
It's an extreme remedy meant for unusual and extreme circumstances. And so where you have a pending lawsuit where a judgment might be entered,
Right.
and in the middle of that secretly, and it has to meet the badges of fraud.
Right, but don't you need more than you showed? And I think that's the position they're taking is that, okay, we did sell the property, but where's the proof that we were engaged in a fraud or that we were, just because it might have the effect of avoiding a judgment, is that enough? That
No. It's not enough. I'm sorry to
No,
interrupt.
go ahead. No, go ahead.
I'm a little jumpy.
Yeah.
The debtor creditor statute enumerates 11 potential badges of fraud because they recognize it's not always easy to directly prove fraud. So if you have some of the indicia or badges of fraud, that shows intent. Your Honor, we meet 8 of the 11. Okay. Was it a transfer involving an insider? Yes. They sold the property and distributed the proceeds to themselves. Did the property revert to the debtor's control? Yes, they distributed the proceeds themselves. Was it done under circumstances of concealment? Yes, we didn't know about it, and we're the 100% assignee owner of the membership interests. Obviously, we should have been informed of it and would have had to approve it. They did it secretly. Fourth, was there a pending lawsuit? Yes, there was a pending lawsuit. Did it sell all or substantially all of the assets? Yes. You can go down the list. One after the next, we satisfy. So this is overwhelming indicia of fraud. It's a very standard kind of fraudulent conveyance situation where you secretly sell an asset while there's a significant litigation pending to render yourself judgment proof. Yes, Rob.
I have a question. I just didn't want you to sit down without me asking it. All right, this order was 2025, and the import of the order was basically that the original action should go forward first. This is, a year later, has that original action proceeded any further?
Well, the summary judgment order came about a year later, and now it's on appeal. Will be before you in a few months, I think.
Okay.
Now, on the underlying issues, I think made clear in our briefs. While the judge below said there's a question of fact as to our contribution to the hacking situation, in the same decision concluded that their agent Stuart Title was liable and breached their fiduciary duties to Cypress. What were those fiduciary duties? It was to handle the closing of a loan and make sure the proceeds, the 10 million, was directed to the right place. So the court has already found actual liability by the borrower's agent. And instead, as to everybody else involved, it's only hypothetical that someone might have contributed in some way. But the court has already found that the substantial and really proximate cause of this loss was the mishandling of the proceeds of the loan by their agent. And so all we're saying is, well, if their agent has been determined to be liable, then they're liable to us on the contract, because what Stuart Title prevented the borrower from repaying the loan and from meeting their obligations under the note. So they caused.
But that's not before us, right?
It really shouldn't be. It's not before you because the judge below kind of imported that into the analysis.
Right.
But really the analysis is much simpler. Might there be a judgment? Was there the potential for a judgment pending? Can you secretly, with all these various indicia of fraud, sell an asset and render yourself insolvent? Yeah. I'll
We
rest
have
on
that
the-
argument, counsel.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Patrick Mackey on behalf of the defendants, respondents in this matter, except for, I want to make this point, Ronald Toski, Margaret Toski, and Lakewood Management Services, but we do represent the remaining respondents in this action. Your Honors, you're fully aware we filed a brief in response to this appeal, raised many points and arguments in that brief, and I don't intend to hit on every one of those arguments, but there are some issues I do want to highlight today, just to clarify that the lower court did make the proper decision in denying the appointment of a receiver and the prejudgment attachment in this case. One thing I think Your Honor should be aware of, and I did include this in the brief, is that there's actually an issue of standing at this point, whether they have a right to bring a motion seeking the relief they ask. And the reason I bring that up is the trial court granted our cross motion to dismiss the 2 breach of contract claims that were brought in this action. And once that happened, and let me back up, and they do not appeal that dismissal. And once that happened, this case turned into an equitable action. There's no monetary damages. This is an equitable action where they're asking for the court to set aside the sale of the property in Florida so that it's put back in its original position. Once this became an equitable action and there's no monetary damages involved, there's no right under the CPLR to attachment. What are you going to attach? Or to a receiver. What is the receiver going to look at? There's no monies involved. So the CPLR is clear that for attachment and a receiver to happen, there has to be a request for monetary relief. That is gone. This is an equitable action. So technically, there's really no more standing in this case for U.S. Income Partners to bring this appeal. Going to the substance of the appeal, as Your Honors are aware, they are asking for drastic relief. And this is relief they supported by a very scant 2.5-page affidavit, which was very conclusory in the way it was presented. There's no proof of fraudulent intent. Just because a sale happened doesn't mean it was done fraudulently.
Where did they put on notice?
No, and they weren't required to, because once they sued on the contract, that contract essentially is null and void. Once they sue, my client is not required to continue.
So if 2 parties, just so I understand that argument, so if 2 parties are engaged in a contract and 1 party commences an action, that voids the contract?
Yeah.
That's your legal argument?
Yes, and I cited I've provided some cases in the brief. Basically, you have 2 options. If you're a party that you feel that the other party has breached, you have 2 options. You could just continue with the contract in hopes that it works out, or you could basically terminate the contract and sue the other side. If you sue the other side, that basically null and voids the contract, and the other side is not required to continue complying with the contract which they're getting sued on. It kind of makes sense because it's not realistic to continue to ask someone to comply with a contract in the same time you're suing them. So there wasn't a requirement for consent to sell the property. But going back to my point is that they provided a very scant affidavit. There's no proof of fraudulent intent. There's no proof of insolvency because of this sale.
And that was what I was going to ask you about. Did the sale of the property render your clients insolvent? Can they ever pay what your opponent wishes them to pay in the long run? Is all the money gone, all the property gone?
Whether they have other assets, I believe they do. I can't say what the value of those assets are, but I don't necessarily believe that they're insolvent just because of this sale. And they haven't provided anything in their proof in support of their motion to support that they would be insolvent because of this sale. The other issue I want to hit upon, and I don't think, and I know counsel has mentioned that we should look at this case by itself and not looking at the underlying matter. I don't think that's possible. And one of the reasons I say that is this is probably a motion that should have been brought in the underlying matter. This is relief that could have been provided in front of Judge Doyle in the underlying matter. I'm not sure why it was a separate action to begin with. And so that being that it may, is that these two actions are basically interlinked. You can't look at one without the other. And the court, when it rendered its decision, realized that and says, you know, there's no probable success on the merits in the underlying matter. There's no probable success that you're going to win, at least against my client, Cypress Point, and the guarantors, the relief you're asking for. So why in this separate matter should I be attaching assets, appointing receivers, basically putting a burden on the defendants when there's a good chance those defendants are never going to owe you that money to begin with? Because, hey, in the first case, I found that there's at the moment no probable success on the merits. So I don't think you can look at the two cases separately. They're interlinked. And the court did say there's questions of fact abound in the underlying matter. The other point is, in the underlying matter, there is almost 30 parties. There are numerous different parties other than my clients who may be found at fault because of this stolen loan payoff. Plaintiff itself could be found at fault. Even if the court decides to apportion fault, the plaintiff could be at fault. And if the plaintiff's at fault, even if it's percentage-wise, that means there shouldn't be any type of relief granted against my client in this matter, the equitable relief that they're asking for. With respect to Stewart Title, it is true the summary judgment was found in my client's favor against Stewart Title. They had an escrow arrangement where my client provided Stewart Title with the money to make the payoff, and Stewart Title has been found liable for failing to make sure that payoff was sent to the correct recipient, which would have been Monroe Funding, which acts as an administrator for the loans for U.S. Income Partner. So the fact that the court has already kind of identified a party in the underlying matter who's at fault in this case basically lessens the ability or lessens the chance of my client being found liable in that case, which again goes back to this lack of probable success on the merits, that my client at the end of the day is going to be found liable for money being owed to the plaintiff, to U.S. Income Partners. With respect to Stewart, I noted the argument that they were the agent of Cypress Point, and because of them being the agent, the principal should be liable as well. And there's several reasons why that argument doesn't flow. And one is that this case, or the underlying case, is really more, it's not really a contract case. It's more of what they call the doctrine of the imposter rule, where the court doesn't look at to whether the loan was paid off and if there's a breach. Because of the facts in this case, the court is looking at who is at fault, who is in the best position to prevent this fraud from occurring. It's already determined that Stewart is at fault. What degree of fault, we don't know yet. But it's already determined that because of this imposter rule doctrine, there's fault already on Stewart's behalf. And
are you saying because of the imposter rule doctrine that your client would not be liable? You're not saying that, are you?
Sure. I mean, there's very much a chance that they would not be found liable. And because
they were never, there's no question they were never paid, right? Because
they did not receive the money.
The people stole the money.
Right. It was over a little over 10 million.
And there's also a judgment against Stewart. So they'd be responsible to you. Maybe you're saying they're responsible to them and not you at all. You're absolved from any because you tendered the money to the escrow holder.
Right. And when you look at agency law, the agent is supposed to act pursuant to the agreement with the principal. The agreement was requiring Stewart to pay Monroe Funding. Stewart didn't do that. They paid some imposters with bank accounts in Mexico. They didn't act pursuant to the escrow agreement, and that relieves my client as the principal from any liability. And at the end of the day, Stewart's actions harm my client as well. My client is out $10 million without getting any value in return. And so it'd be difficult for my client to suffer because of Stewart's action.
They will get value if they don't have to pay, right? I mean, they're absolved, so it's as if they did pay.
If that's how it ends up, sure. But at this point, their $10 million is gone and they have no value for it. And Stewart's actions harmed both U.S. Income Partners and my client. If they harmed my client can't be liable for the harm Stewart caused on them. So, like Your Honor says, Justice Whalen says, this is a very unique case, unusual case. There's a lot going on. There's multiple lawsuits. There's, looking at contract law, maybe that doesn't apply. It's the imposter rule that applies. There's a lot going on in this type of case. And then finally, Your Honors, I just want to hit upon Well, a couple of other things. One of the comments that council mentioned that the debtors and creditors law says that, there's only might be a fraudulent event. That's for pleading purposes. They have to plead that there might have been some type of fraudulent event. Under the CPLR, if you're looking for attachment and receiver, that's a much higher standard, which I'm sure you're aware. And they have to provide some type of evidence that there's been fraudulent intent in an insolvent defendant. Lastly, with respect to the stay that the lower court entered for discovery, as you're fully aware, there's broad discretion with the trial level court to grant a stay if they feel it's appropriate. And in this case, we submit that it's entirely appropriate because, and it says this in their decision, in the lower court's decision, the underlying lawsuit, the original lawsuit, may very well render this lawsuit moot. And so there's no reason for parties to spend time and money going through discovery in this particular lawsuit when they may never need that discovery to begin with. And what I mean by that is if the underlying lawsuit finds no liability against Cypress Point and the remaining of my clients, there is no need to find out where this money supposedly went. Unless your honors have any other further questions, I rest.
No other questions. Thank you, counsel.
Thank you.
Case 439.1.
Good morning, Your Honor.
Hello, counsel. Counsel, we of course have the same lawyers arguing two cases. So I'm going to actually leave it up to you to tell me what your preference would be. Would you prefer to argue both cases at once as appellant and then both respond, or would you want to be up and down?
I'll defer to respondent. Do you have a preference? It's really to the court's discretion. I can obviously
Let's
summarize
both cases and then respond to both cases. Very good. All right. Thank you, counsel. Proceed.
Thank you. May it please the court, Brady Parmentier appearing on behalf of both petitioners, that's Thomas Short and Martha Arcelius Torres. The actions before your honors concern two duly filed invalidation proceedings that petitioners submit were improperly dismissed without a hearing when the lower courts obviously sided with respondents here that the underlying petitions were not sufficiently pled. We just flatly disagree with that, your honors. We in fact submit that the respondent candidates designating petitions were full of fraud on a variety of levels, and that fraud was properly and sufficiently pled to warrant a hearing on the matter. There were obviously substantial factual issues that were raised in the verified petitions that warranted obviously testimony and factual findings of an evidentiary nature. I'll turn first to the motion to dismiss standard. Looking at CPLR 3211, your honors, it would be that you would need to accept as truth the allegations put forth in the pleading. That would be you accepting that the allegations of fraud did in fact occur, and such that we would be entitled to a hearing and it would not warrant dismissal relative to a motion to dismiss that was moved on by the respondents therein. Here we submit that petitioner sufficiently pled the allegations of fraud in each petition to apprise the respondent candidates. It was included in each petition, the lines, the signatures, and the subscribing witnesses that we purport actually committed the fraud, sufficient enough to give the respondent candidates notice of the fraud that we were alleging exists. Moreover, although not required, we included in both verified petitions at least one affidavit. That affidavit did squarely comport with what we were alleging, that fraud existed in the petition. Now, obviously, that allegation was just limited to a single signature line, but that was one of the signature lines that were so preserved in the specific objections filed by the petitioners. Again, we submit that that was not even necessary. It was enough that we had those allegations specifically pled in the pleading. The suggestion by respondent candidates that we needed more affidavits in order to pursue the claims is simply perverse, I suggest, and contrary to the pleading requirements otherwise necessary. Turning first to the fraud we allege relative to the individual signatures. Obviously, this court is aware signatures on a designating petition need to conform with the signatures of one's voter registration card. We specifically delineated the number of occasions in which the signatures that were in either candidate's designating petition did not comport with that which was in the voter's registration cards. I'll turn specifically here to candidate Hoke. There were 14 subscribing witnesses we alleged to have committed a fraud, 16 in candidate Zellner's designating petition. Relative to candidate Hoke, we allege in the verified petition that 2 of those purported fraudulent subscribing witnesses were in fact related to the candidate, as we allege, obviously in our motion, or I'm sorry, in our memorandum of law. If that fraud was committed by family members of candidates, that fraud can be imputed on the candidate themselves, even if that candidate didn't necessarily herself commit the fraud. So here in the in the verified petition of respondent candidate Hope, we've further alleged, outside of candidate Zellner, that candidate's family members also participated in fraud that would warrant, again, an examination and hearing whether or not that fraud that's so alleged or exists is chargeable to the candidate herself. If we were to include not only the specific allegations of fraud we allege the subscribing witnesses committed, but also the handprint signatures that don't comport with the signature cards at issue, this now expands to so much greater of the portion of the designating petition of respondent candidates. First, I'll begin with candidate Hoke. In candidate Hoke, if we were to include the 45 additional signatures that we specifically pled in the verified petition were handprint and not in conformity with the voter registration cards, this would implicate another 16 subscribing witnesses. This would total 30% of the subscribing witnesses within that designating petition and invalidate more than 37% of the designating petition sheets so submitted. Again, if we were to prove at a hearing that fraud did occur. And again, at the stage of a motion to dismiss, you must accept as being true. Turning now to candidate Zellner, in this case, there were 122 instances of handprints that did not conform or match with voter registration cards. And if we were to include here too, those subscribing witnesses and attribute that fraud also occurred in those instances, that's 23 subscribing witnesses that would have committed fraud, invalidating, again, if we were to prove fraud existed on those occasions, then 23% of the total designating petition of candidate Zellner's petition. This level of fraud, whether it be 30 or 23%, is not de minimis. It is substantial, and we allege it rises to the level of permeation of the designating petition. Fraud in election law is not necessarily measured in volume. I think intentional falsification calls into question the entirety of the designating petition, and that has so been stated in Your Honor's prior decisions. Permitting fraud at this level incentivizes campaigns and candidates to engage in misconduct, which they can later characterize as insignificant, as has been done in this case, and face no real consequence. Here, honest candidates complying with the law are disadvantaged. If I may just very specifically point out here too, with relation to candidate Zellner's petition, in this case, there were over 4,500 signatures that were submitted. That is well in excess of what was required, more than 3 times what was required. I'll note too that if Your Honors were to consider 4,500 signatures, using 1 minute of time to compare that signature to that of the voter registration cards, which I think is actually very minimal, if you consider the time it takes, that's over 76 hours that would be spent exacting each signature to the designating petition. I bring this up because that is a nearly untenable amount for anybody wishing to examine whether or not these were actually good signatures. And I submit perhaps this was a purposeful ruse to hide the fraud that we knew to exist on its face in the designating petition. And on that, I'll turn to the fraud relative to the petition alterations. You can see on the face of both of the designating petitions of the candidates that fraud existed on its face, at least relative to the alterations that we, again, exactingly submit exist. These alterations are undeniable, they're improper, they're unlawful, and they are pled with great specificity, similar to the case of Abraham versus Ward before Your Honors. Such alterations do not comport with either the signators or the subscribing witness signatures. And it's across a multitude of pages in both designating petitions, indicating systematic tampering of the designating petition is what we allege. Moreover, the allegation in the designated petition that these changes were done at the direction either of the campaign or the candidate himself would then impute the fraud on the candidate. Obviously, as this court is well aware, fraud committed by the candidate invalidates the petition as a whole, regardless of the number of otherwise qualifying signatures. We submit then, and this is obviously supported by the case of Hager
Haygood versus Hardwick. I know that's a second department case, but your honors also ruled on this in Buchinsan versus Salentino. Minimally, with regards to the alterations on the face of the designating petitions that we can see quite clearly, a hearing could have been held and should have been held relative to that allegation of fraud. It specifically pled and it was unrebutted. Lastly, I'll turn to fraud in the commissioners of deeds, which again is alleged in both of the verified petitions before your honors. Executive law section 139 subsect 8 does not statutorily state that cities can grant commissioners powers outside city limits. Here, there is no question certain subscribing witnesses, as we've specifically alleged in the verified petition, committed notarial acts outside of the city in which they were so empowered. If you look at those designating petition sheets, on its face, it specifically says those commissioners of deeds are empowered within the city of Buffalo. You can also see on those same designating petition sheets, those commissioners of deeds acted outside the city of Buffalo, whether it be Hamburg, town of Tonawanda, or I believe the town of Amherst, your honors, in the instance of candidate Zellner. In any case, fraud committed by a commissioner of deeds is imputed upon the candidate. I know that obviously my opponent is focusing on the case before your honors in 1987 of, I'm going to mispronounce this probably, Philosophos versus Smolansky. I've reviewed that decision. I reviewed the decision obviously before I ever pled the verified petitions at issue, and I seemingly don't think that that examines specifically that there is no powers extended in executive law to allow the city of Buffalo to expand the powers outside of the city of Buffalo. There is nothing in the state that provides such a provision. It would be as if the city of Buffalo is now empowered to adorn each of you as prince or queen of Great Britain. It simply is not permitted. You know, it's simply anything written in that code is just improper and falls against what is obviously statutorily extended in Executive Law 139. Lastly, and I'll just point out, obviously my opponent takes some issue with the exclusion of certain documents that were in the NICEF record that were not included in the record on appeal. Relative to candidate Hoke, I know my opponent brings up that memorandums of law were not included. As your honors are aware, that's not required to be included in the record, so those were properly omitted. Relative to candidate Zellner, petitioner has included the entire record at issue. I think what respondent fails to necessarily recognize is that when she so moved in the motion to dismiss, which is what we are in fact appealing, she failed to properly cite or incorporate any of the prior record such that that did not need to be included in the record before your honors. Nonetheless, appellant has included certain documents which I thought would be necessary for this court to consider. You can see in the table of contents of the record on appeal, I have so cited that while it doesn't include an exhibit number, it certainly was included therein. So I would submit, certainly, I have provided to your honors the entirety of the record that would be before your honors on appeal. In conclusion, obviously, I think there's fraud in a variety of species that have been alleged in the designating petitions. That have been alleged in the verified petitions, such that the designating petitions both would qualify to have a hearing so that the lower court can determine whether or not the fraud that exists either permeates the designating petitions or can be imputed upon the candidate such that obviously it would invalidate the petition in its entirety. If your honors have any questions?
No questions, counsel. Thank you.
Thank you, your honors.
Good afternoon, your honors. May it please the court, Kate Lavin for respondent candidates Jeremy Zellner and Karen Hoke. I appear before the court this afternoon on two indistinguishable appellate briefs, each arising from equally boilerplate verified petitions filed against two different candidates seeking two different offices. That uniformity between the petitions and between the briefs today is not incidental. Rather, it underscores the petition's fundamental defect, which is the complete absence of factual specificity tailored to either candidate's designating petitions. A petitioner may not invalidate a sufficient designating petition through conjecture and isolated assertions. As this court is well aware, CPLR 3016B requires fraud allegations be pled with a heightened specificity, precisely to prevent the kind of speculative pleadings that we have before the court this afternoon. Granting appellant's request would create a dangerous precedent. Any alleged isolated defect could be leveraged into allegations of systemic fraud. Any volunteer's alleged misconduct could be attributed to a candidate through conclusory assertions of constructive knowledge. The inevitable consequence would be increased election litigation, strategic candidate harassment through proceedings, unnecessary judicial involvement in political disputes, and the potential disenfranchisement of voters based solely on speculative pleadings. Appellant cannot utilize the hearing with which she requests that she says she is entitled to cure her defective pleadings. To do so is entirely to ignore the pleading requirement and to make CPLR 3016B meaningless. As the court is aware, there are distinct legal theories of fraud in designating petitions. First, that the designating petitions contain an insufficient number of valid signatures. Second, that designating petitions are permeated with fraud. Or third, that there is candidate knowledge of or participation in alleged fraud. As this court is aware that minor irregularities, isolated defects, invalid signatures are not uncommon in designating petitions. Election law accounts for that reality by permitting line-by-line objections. A petition proceeding on a theory that there's an insufficient number of valid signatures that appends specific objections to it, that may plead a sufficient case to move forward. However, as this court recognized in tolls, signatures that fail to correspond to voter registration forms, such as appellant raises today with respect to cursive versus handwriting, those signatures should be stricken, but same does not invoke the permeation doctrine. In recognition of this distinction, the verified petitions themselves separate the line-by-line objections from the allegations of fraud. Even if the court were to have had a hearing and found clear and convincing evidence that every fact pled by appellant in her petitions were proven by clear and convincing evidence, and even if the court invalidated all signatures included in the specific objections, all signatures included or all signatures witnessed by the subscribing witnesses with which appellant takes issue. With respect to candidate Hoke, 1,099 signatures would remain when only 500 are required. With respect to candidate Zellner, 2,853 signatures would remain when only 1,000 are required. So there is almost triple the amount for respondent candidate Zellner and more than double the amount for respondent candidate Hoke, even if she had proven every allegation in her petition at a hearing by clear and convincing evidence. So unable to rely on the numerical insufficiency of the petitions, the entire case, as appellant acknowledges in her brief, must rest on whether the petition adequately pleads permeation of fraud or candidate knowledge of the fraud. What appellant attempts to do here is to take ordinary objections and repackage them into sweeping fraud allegations sufficient to force a discovery-like hearing and compel witness testimony. But permeation of fraud requires fraud so extensive that the integrity of the petition as a whole is compromised. This is supported by this court's precedent, and it is supported by Election Law 16-1023, which authorizes the courts to invalidate petitions, designating petitions, when there has been such fraud as to render impossible a determination as to who was rightfully nominated. In support of her permeation allegation, she submits three allegations, which is first, relating to the commissioners of deeds. Appellant brings up the Philosophos decision. This court held that Buffalo commissioners of deeds may act throughout Erie County, and the Buffalo City Charter similarly expressly authorizes countywide authority to do so. Even if appellant doesn't like that law, even if appellant thinks it's wrong, the commissioners of deeds' reliance upon that law in getting those signatures in County of Erie cannot be said to be fraudulent. Fraudulent requires some sort of knowing, intentional, willful conduct. So their reliance on this court's precedent and this Buffalo City Charter cannot be fraudulent, even if appellant doesn't like it. Second, regarding the alleged improper alterations with respect to candidate Hoke, it happened on, or is alleged to have occurred on one single sheet with respect to 10 signatures on that single sheet. With respect to respondent candidate Zellner, it is alleged to have occurred on eight improper alterations, 3 with respect to signatures, 5 with respect to towns or cities below the witness signature line. Even accepting those allegations of true, those allegations are undeniably isolated and insignificant. And even striking all signatures on those pages, like I mentioned before, we would still be at a sufficient number of signatures for both candidates. Third, regarding the alleged forged signatures, appellant submitted with her petitions for both one affidavit relating to one alleged forged signature pertaining to one witness. This court's precedent under Diermeyer specifically states that that is insufficient to invoke permeation of fraud. In fact, the court didn't even invalidate all sheets witnessed by that subscribing witness, but rather the court just invalidated that single signature. That one affidavit is insufficient to plead permeation of fraud. Then, petition then speculates regarding other potentially forged signatures. First, I would say that said speculation is insufficient under 3016B, but as appellant stated, we have to accept as true all of the facts that she pleads. So accepting that as true, and even assuming the truth of the conjecture that she includes in her petitions, there is no pattern alleged, there is no allegations of concentrated misconduct, there is no factual nexus pled connecting the isolated allegations. The alleged irregularity touched a small percentage of sheets in the designating petitions. With respect to candidate Hoke's petition, the total signatures collected by all subscribing witnesses with which appellant takes issue, including Mr. Little, with which the affidavit was included, is 289 signatures with respect to candidate Hoke. With respect to candidate Zellner, it's 536. That's 16% of signatures for candidate Hoke and 12% for candidate Zellner. That is numerically insufficient, but also it does not plead any connection between them. This case is in opposite to Saunders, which this court found that the credibility collapse of 5 subscribing witnesses who had collected the overwhelming majority of signatures tainted the entire petition. This case is nowhere close to that. With respect to candidate Hoke, she does not allege any fraudulently procured signatures against 92 subscribing witnesses. With respect to candidate Zellner, she makes no fraudulent allegations against 217 subscribing witnesses. There is no allegation that any of the witnesses with which she takes issue collected the overwhelming majority of signatures. The diffuse allegations here undermine any evidence that the petition in its entirety was compromised, and she has failed to sufficiently plead permeation of fraud. With respect to candidate knowledge of or participation in alleged fraud, I will briefly say that there is not a single non-conclusory fact included in either of the verified petitions that connect respondent candidate to the alleged fraud. Under her proposed standard, any claimed defect by any volunteer, no matter how isolated, could be repackaged and attributed to the candidates through conclusory pleading. There has to be some facts alleged. Who engaged in the misconduct, and what is the fraudulent actor's relationship to the candidate or the campaign organization, and the circumstances from which knowledge can be charged to the candidate. Constructive knowledge is simply insufficient under 3016B. With respect, finally, I will just note that because the petition rises or falls on whether the petition adequately pleads permeation of fraud or candidate knowledge of the fraud, and because she has failed to adequately plead those and otherwise concedes the numerical sufficiency of the designated petitions here, the Supreme Court's order below must be affirmed. Ultimately, as this court recognized in 1974, this court is required to construe liberally the election law to the end that the voters be afforded the fullest opportunity to exercise their franchise. Your Honor, appellants' duplicative petitions provide no concrete particularized facts of fraud, and 2 separate Supreme Court justices independently reviewed these petitions and reached the same conclusion. The pleadings here are legally insufficient. Accordingly, the Supreme Court correctly dismissed the petition because she has failed to plead permeation, candidate knowledge of fraud, with the requisite specificity, and she otherwise concedes that they possess significantly more than the required numbers of signatures. So we would ask that the decision below be affirmed.
Thank you, counsel.
Thank you.